Unmute.
Is it audible now?
Yeah, yes, audible.
I was mute, sorry. So before we begin the discussion, this is something which is the most debatable. One may call it grounds to dispute, grounds to challenge approved resolution plan. That is how Ruchi Soya has used it. As far as this particular section is concerned, section 29A is concerned, that is one of the most crucial tasks for a resolution professional, both at the time of inviting that resolution plan and at the time of verification of that resolution plan, before tendering the same, before placing or before set forthing the same before the committee of creditors. Now, as far as 29A is concerned, this can be one of the reason multiple firms of chartered accountant or company secretaries and even advocates are being engaged, are being hired by, or the services are being availed by the insolvency professional during the course of their role as an IRP or the RP. Because this is something altogether exercise which requires utmost due diligence. And you have to take care of for all the resolution plan which is coming your way in order to place it before the COC. So ultimately, it is a due diligence on the part of, so you cannot rely, being an IRP or being an RP, you cannot rely upon the affidavit which is given by the proposed resolution applicant at the time when they place their expression of interest. Or you cannot solely rely upon the affidavit or declaration which is given by the resolution applicant while submitting the resolution plan. So onus cast on the resolution professional, and that is what in Astraya matter of Haribabu Tota, the Supreme Court judgment, that is very clear, wherein the RP has taken up the stand to accept the resolution plan of the promoters, which was approved by the COC, but ultimately it was rejected, and thereupon the matter went to NCLAT and Supreme Court. And Supreme Court has made the things clear that when it will be considered whether the promoter of the corporate debtor, being an MSME, at what stage their eligibility is going to be taken care of. So we will be dealing into that aspect also. But as far as 29A is concerned, there are multiple layers. So it is not only the one who is placing the resolution plan, but you also need to take care of, if one is placing a resolution plan jointly with some other person, then you need to take care of 29A for both this individual or both this person who are placing a resolution plan. It's not only up to that extent. You need to take care of the connected persons. So that is also provided as an explanation to 29A. So you need to extend your reach of due diligence to that connected person. And thereafter, not only the connected person, but you need to check, apart from the person who is placing a resolution plan or apart from a joint resolution applicant or the connected persons, you need to check the related parties of that connected person. So you need to extend your reach up to that level in order to come to this conclusion that whether they are eligible as a resolution applicant under 29A, and then only the same will be placed before the COC for their approval. So onus is on the resolution professional to verify it, and that is the only reason when we accept a resolution plan, it is a list of connected person or list of related parties are generally demanded from the resolution applicant who are set forthing a resolution plan for the approval of the COC. So we will be dealing into, as far as the session is concerned, we will be dealing into multiple aspects, but foremost is going to be the code. The provisions of the code is going to be taken care of first. We will be dealing the same with the resolution, that with the regulations, that is IBBI insolvency resolution process for corporate persons regulations. We will be dealing into the liquidation regulations also, and we will be checking in what stages or wherever the process will continue as a CIRP will continue or the liquidation will continue as a RP or as a liquidator, wherein I need to keep that check, or wherein I need to keep a very much a concise, or wherein I need to have a very clear vision of their eligibility. Because in case if this corporate debtor goes into liquidation, then even a asset of the corporate debtor will not be, or that cannot be acquired by a person who is not eligible under 29A. Not only this, once the decision of liquidation is taken by the committee of creditor or in absence of any resolution plan, when corporate debtor goes into liquidation, there is always an efforts under section 230 of the Companies Act 2013 through compromise and arrangement, through which there is a possibility of revival of the corporate debtor before going into the liquidation or getting dissolved. But at that time also, when you are putting a proposal under section 230, if you are not eligible under 29A, you will not be considered eligible to put your scheme before the NCLT or the adjudicating authority under section 230 of the Companies Act 2013. So we will be dealing into that aspects also. But yes, there is a myth, and that myth says just because I'm a promoter of the corporate debtor, or just because I was the promoter of the corporate debtor, that does not debar me to place a resolution plan. And that unclaimed judgment also we are going to deal into that aspect. So if I was the promoter of the corporate debtor prior to initiation of CIRP, or even at the time when CIRP was going on, I was a suspended management, I was a promoter. But suppose if I take all the columns of ineligibility, that means suppose if I'm not ineligible under 29A, just because of I was a reason for that corporate debtor to go into CIRP, that does not stop me to propose a resolution plan. So what exactly need to be taken care of is whether I'm disqualified under the law, whether I'm disqualified under the act to become a resolution applicant. Now, suppose if I'm matching all the requirement and I'm not falling into that negative list, just because of I'm the promoter or I was the board or I was a related party to the board, that does not stop me from placing a resolution plan before the resolution professional for its approval before the COC. So we will be dealing into the aspect of the code first. And after going through the provisions of the code, we will be taking into consideration certain judgments. But yes, just a background check we need to have. And after going through that, what exactly the challenges which were, because the constitutional validity was challenged. It was not 29A which has got an easy mandate from the stakeholders. It was challenged before the Supreme Court, and it was the Swiss ribbon case, leading to which the constitutional validity of this 29A was also challenged, and it crossed those hits of the stakeholder. And Supreme Court has made it the things very clear that the company will not be handed over to the same promoter, the promoter who was responsible for the same company to go into the insolvency. So we will be dealing into that aspect also, that how 29A was challenged before the Honorable Supreme Court and how the constitutional validity was upheld by the Supreme Court in the matter of Swiss ribbon case. We will be dealing into the aspect of the code first, and then we will be dealing into all the relevant rulings or judgment in this regards. I'm just sharing a screen for the sake of convenience of the participants, and that is going to be the code itself. From the Bear Act, we will be dealing into the same, and after completion of the same, there are certain judgments which I will be taking upon and going through the code first. Is the screen visible?
Yes, sir.
Yes.
Yes, sir.
Thank you, sir. Thank you.
Yes.
Yes. So as far as the most crucial part to take care of, as far as this particular code is concerned, we need to take care of that who are entitled to place a resolution plan. Because when you see the definition of section, or when you see the provision of section 29A, it directly starts with the person. So meaning thereby, a resolution plan can be put forth by an individual, again, subject to their eligibility under 29A, or subject to the condition that they are not disqualified under 29A. But in the individual capacity, the plan can be placed. And yes, when an individual is placing a resolution plan, it is again very important that you need to take care of the eligibility, not up to the extent of this individual, but you need to check the related parties. You need to check the connected persons, person acting in concert, which is not defined under the code, but we used to get its meaning from the SEBI, and that is when we see this particular provision, that substantial acquisition of shares takeover code we used to check in order to take care of the definition of person acting in concert. So who can place a resolution plan, and that can be identified from the definition of the person, which is there under section 3 clause 23. That is an individual, Hindu undivided family, a company, trust, partnership, limited liability partnership, or other entity established under a statute, and include a person resident outside India. But if a person is residing out of India, we need to check the eligibility criteria as per the law of that host country, as per the law of that country wherein a person belongs, and placing a resolution plan. So this is very clear cut indicated in section 29A, that if any of the provision or any of the clause which is there in 29A, if there is a governing law in the country, in the host country, or in the country wherein a person is placing a resolution plan, now suppose if that country debars him because of that ineligibility as per the law of that nation, he will not be entitled to submit a resolution plan under the code. So as far as this person is concerned, it is an indicative list that who can place a resolution plan. And yes, it can be any combination thereof. It can be by an individual, or by an HUF, or by a company, or a trust, or a partnership firm, LLP, or other entity established under a statute which includes a person which is residing out of India, including a foreign company, and it can be an individually or jointly with other person. So this is definition which is quite crucial to identify whether a person is fulfilling the criteria of the definition which is defined for person under clause 23. As far as section 5 is concerned, now section 5, which has made the things very clear, that who will be defined as a resolution applicant, and that is under 5 clause 25. And when we'll be dealing with the resolution applicant, the definition has been drastically changed because of the amendment under the code, and that clearly indicates that a person who individually or jointly with other person, and that is what we were dealing, that it can be an individual proposal or it can be a joint proposal while tendering a resolution plan. That is there under 5 clause 25. The resolution applicant means a person who individually or jointly with other person submits a plan to RP pursuant to invitation. So basically, it is one of the most crucial role which RP has to play, and that is 25(2)(h), that is invitation of EOI. They generally set forth the criteria considering the condition or considering the business operations of the corporate debtor. They decide the parameters, and apart from that, they decide that apart from this parameter, the applicant or the investor, whosoever is proposing a plan, should not be ineligible as far as the 29A is concerned. So as far as the resolution applicant is concerned, it means a person who individually or jointly with other person submits a plan to RP pursuant to invitation made under 25(2)(h). And there is again a definition of the related party. And we will be dealing into that aspect once we will be taking care of section 29A. And yes, the provision which I was just referring, and that is 25(2)(h). And this is quite crucial, because when a person is acting as an RP, it is his responsibility to invite or to get the form number G published, invitation for expression of interest. And that includes whenever a RP is inviting a prospective resolution applicant, then he has to specify that who shall fulfill the criteria as laid down by him with the approval of the COC, having regards to the complexity and scale of operations of the business of CD, and such other condition as may be specified by a board. But one of the foremost condition, irrespective of the parameters set out by the RP during the course of inviting EOI, 29A is something which one has to take care of. And as far as the provision of section 29A is concerned, it clearly indicates a negative list, and that states that the person's not eligible to be a resolution applicant. Meaning thereby, you need to extensively go into the depth of the definition, up to what extent it may be applicable, not only to the one who is the face, but also to the person to whom it belongs, basically. So as far as this person not eligible to be a resolution applicant is concerned, we need to take care of 10 criterias, but there are multi-layers things which we need to take care of, because we need to go first of all a person's ineligibility. Then we need to check the connected persons ineligibility. We need to take related parties ineligibility. And suppose if a person is placing a resolution plan jointly with other person, then co-resolution applicants, related parties, co-resolution applicants, connected persons, we need to dwell the due diligence up to that extent. So layer number one is when that ineligibility will extend only up to the resolution applicant, but when it get extended, it need to be taken care of that who are the connected parties, and not only that, the related parties of this connected parties. And in case, as I said, that if I'm the applicant and I'm placing a resolution plan together with some other person, then this layer while taking a due diligence will be extended to him also. So let us begin with the first disqualification, and that is undischarged insolvent. For a person, I can say, if it is a body corporate, of course, a company which has not got a resolution plan, if it is in CIRP, and if it is a person, then in case part 3 proceedings have been initiated, insolvency, what is applicable right now or what is notified in part 3 is against the personal guarantor. Now, suppose if the insolvency proceedings have been initiated, but I have not got a discharge order from the adjudicating authority, or if no repayment plan is approved by the committee of creditor in case of personal insolvency, though not notified apart from the persons who are a personal guarantor, but suppose if it get notified, so Presidency Town or Provision Insolvency Act. Now, suppose if the insolvency proceedings are pending and I have not received a discharge order from a court, or a personal guarantor has not received a discharge order from the adjudicating authority, I will be treated as an undischarged insolvent. And if I'm undischarged insolvent, then in that case, I am not considered as an eligible person to place a resolution plan. Now, suppose if we go into a definition of connected, or the clarification which is provided for connected person, then it is provided here that as far as the connected person not eligible under clause A to I, connected person means a person who is the promoter or in the management or control of the resolution applicant. Meaning thereby, suppose if a company is placing a resolution plan, then the promoter which are identified by the company in its annual return, whosoever are acting as the promoter of that company, they will be treated as a connected person. Or whosoever is in the management or control of that resolution applicant. Management is prima facie the person who is on the board or its key managerial personnel. And control is again a person is having a control over the resolution applicant is pertaining to its shareholding pattern. So as far as the company being a resolution applicant is concerned, then I must say, for in that company, you need to extend its reach to the person who are the promoter of the company or who are in the management or control of that company. They will be treated as a resolution, or they will be treated as a connected person. And being a connected person, the eligibility of clause A, which we have discussed, that person should not be an undischarged insolvent. In that circumstances, that will be applicable to all this layer. So I said, as company is placing a resolution plan, then you need to keep an eye on the eligibility or ineligibility under 29A to the promoters of the company's board members or key managerial personnel and the person who is having a control over that company. So this clause A is extended to that level. That means they will be treated as a connected person. Not only that, the connected persons also includes Suppose if our company is placing a resolution plan, and in the resolution plan, company is mentioning that post the acquisition, they will be the promoter, or this will be the on the management, or they will be holding the company shares, having the controlling powers of the company. So in case if the persons whose names are, or the person who will become the promoter of the company, or the person who will be in the management or control of the business of the corporate debtor, now suppose if they are disqualified, then in that case it will make the resolution applicant who is proposing a resolution plan as disqualified, because the disqualification will also extend to those people whose name are mentioned in the plan, who will be acting as a promoter, or who will be in the management or control of the corporate debtor business during the course of implementation of the plan. And third one is, now if a company is proposing a resolution plan, that company is holding, that company's subsidiary, that company's associate company, or related party of the persons referred in clause 1 and 2. So basically, when we will be dealing into any of the ineligibility, this connected persons layer, and in the connected persons definition itself, there is a mentioning of the related party of the persons referred to in clause 1 and 2. So I said, when you see clause 1 and 2 of this explanation, one deals with, suppose if a body corporate is submitting a resolution plan, the promoter of the body corporate, the persons who are in the management of that body corporate, and persons who are having a control over that body corporate. Not only this, if I am placing a resolution plan and mentioning the fact that this corporate debtor, post the approval of the plan, will be managed by this persons who is going to be the promoter, or this persons who are going to be on its board, or this persons who are going to hold the share. Now suppose if they persons to whom you are proposing as a promoter, to whom you are proposing as a management, or to whom you are proposing as a controlling shareholder, if they are disqualified under 29A, then also the purpose of 29A will be different, meaning thereby then also you will not be considered eligible. And third one is, if your company is the resolution applicant, you need to check your holding, your subsidiary and your associate, whether that is qualified as a resolution applicant, and the related party of the persons which are specified in 1 and 2nd clause of this explanation. So basically an extensive or in-depth due diligence you need to undertake. This is clause A, a person which is an undischarged insolvent. This is 29A clause A. Person undischarged insolvent, and here I would like to say the definition of person is not only akin to an individual, but we generally call insolvent. The word insolvent is akin with an individual. But yes, if we see a person as a body corporate, then meaning thereby if a person is going through a CIRP process, for that company will be considered disqualified or ineligible. Now, second one is willful defaulter in accordance with the guidelines of the RBI under the Banking Regulation Act. So basically, if a person is placing a resolution plan, if he is declared as a person who is called as a willful defaulter, this list get published in accordance with the provisions of the Banking Regulation Act 1949. And again, I would like to say that this will not only reach, basically it means the promoter or the persons who, in spite of having the sources, have failed to repay to the bank, or the amount have been siphoned or not utilized for the purpose it was accepted, right? So basically there are parameters which are provided, and there is a master circular in this connection, and from time to time the list is publicly available in the public domain. And during the course of due diligence, we generally rely upon the public search in this regard, or most of the data, and generally the data can be relied upon the information which is provided by the bank also in this regards. But yes, we go fill the CIBIL of the corporate persons, and we used to see the background check whether the person's name is there in the willful defaulter list of the RBI or not. And again, as far as this clause B of 29A is concerned, it also hold its reach not only to the person who is placing a plan, but also to the related parties or to the connected person. And as I said, the connected persons, if a company is being a resolution applicant, then you need to check the connected persons include the company's promoter or those who are in the management of the company or those who are in the control over that company. And suppose if I'm placing a resolution plan and mentioning that they are going to be the promoter or they are going to be on its management or this people will be having the controlling power, then you need to check even their eligibility. And if a company is placing a resolution plan, then in that case, holding subsidiary and associates. And as I said, as far as the individual is concerned, you need to check the related parties of the persons which are specified in clause A and clause B. Now, this is something which is relevant. This is something which is very relevant, and that is what has its roots from SR. And so, in case of SR, it was very much clarified by the Supreme Court of India. As far as this clause C is concerned, this is section 29A subclause C, which states that at the time of submission of the plan, at the time of submission of the resolution plan has an account or account of the corporate debtor under the management and control of such person. Now, this is something which need to be understood, you can say, in a very clear chronology. Now, suppose if I'm the one who is placing a resolution plan and my account was classified as an NPA. At the time of submission of the plan, account was classified as an NPA. Or I was the one who was direct in charge of the management or control of the corporate debtor. So this is what provided account of the corporate debtor under the management or control of such person or whom such person is a promoter. So meaning thereby it clearly indicates that the promoter of the corporate debtor, they are not eligible. First, if their own accounts have been classified as an NPA, or the company's account, the corporate debtor account, which was classified as an NPA, but controlled during that particular phase, the control over the corporate debtor's account was with the person who was in the management or the person who was having a control or the person who were the promoter of that corporate debtor. And if it was classified as an NPA, in accordance with the guidelines of the RBI under the Banking Regulation Act, or guidelines of any financial sector regulator issued under any law for the time in force, and at least 1 year has elapsed from the date of such classification till the date of commencement of the CIRP. This is very relevant. 1 year should have been elapsed from the date of classification till the date of commencement of the CIRP. Now, suppose if that 1 year is not elapsed, this disqualification will not attract. But there are something which is beyond this, which is clearly stating that I will be eligible. Now, this is the way through which you can, or government of India has eyed upon reducing its NPA. I will be eligible to submit a plan if I make the payment of all the overdue amount with interest and charges relating to NPA before submission of the plan. But there is a time frame of 30 days which is provided, which we are dealing under section 30. But again, I'm going to the section 29AC, which states that as far as clause C is concerned, the ultimate intent of bringing this 29A is to keep the corporate debtor away from those promoter, those who somewhere they were the reasons or they have contributed to a great extent with regards to the present position of the corporate debtor, which is in CIRP. So this clause C clearly indicating the fact that suppose if I'm the person whose account was classified as an NPA or account of the corporate debtor under the management and control of such person. So I was the one who was on the board, or I was the one having a control over the company when company, so pre-CIRP stage, or I was the one who was the promoter of that corporate debtor, but account was classified as an NPA, and I may or may not have contributed to this NPA, but yes, I have always considered as a person who contributed, or I was a person though in spite of having a control over the management, or in spite of having a role in the management, did no efforts to keep the company out of the NPA. So basically, a person whose account was classified as an NPA at the time of submission of resolution plan, or a person who was in the management, or a person who was having a control over the corporate debtor, and the person who was the promoter of that corporate debtor, and that company's account was classified as an NPA in accordance with the RBI guidelines issued under the Banking Regulation Act, and 1 year is elapsed from the date of such classification till the date of commencement of the CIRP, then I will not be treated as a person who shall be entitled to place a resolution plan for the corporate debtor. Now, there is a relaxation which is given for the MSME promoter, but yes, right now not touching upon that aspect. Clause C is very clear with regards to its ineligibility, that at the time of submission of the plan, having an account or account of the corporate debtor under the management or control of such person, account of the corporate debtor under the management and control of such person, or whom such person is a promoter, is classified as an NPA in accordance with the guidelines of RBI issued under Banking Regulation Act, and 1 year is elapsed from the date of such classification till the date of commencement of the CIRP. But this SR case has made one thing also clear, that I can be get an eligibility back if I make the overall payment or the overdue payment with interest and charges relating to NPA before proposing a plan. Now, this C is something which is very crucial. As far as this clause C is concerned, what I would like to say is this can be one of the reasons. So this is the heart of 29A, one can say, which actually debears, because I have not seen the promoters being undischarged insolvent, except in the case wherein the secured creditors are moving an application under section 95 against them as a personal guarantor, that make them disqualified or ineligible under 29A clause A, or rarely it happens, or not possible in every cases, that name of this promoters are in the list of the willful defaulters of the Reserve Bank, of the RBI. But yes, this is what you can see, that the corporate debtor which is in CIRP account classified as an NPA, though promoter's account is not classified as an NPA, if the promoter's own account is classified as an NPA, or director's own account classified as an NPA, or the person who are in the control of that company, corporate debtor, if their own account is classified as an NPA, they are clear cut out of the race of 29A eligibility. But suppose if the corporate debtor's account is classified as an NPA, and I'm the person who was the promoter of the corporate debtor, or was in the management of the control of the, I said I was in the management of that corporate debtor, or I was having a control over the operations of that corporate debtor, that also will make me disqualified. I said this will also make me disqualified to bid for my own company. In that circumstances, even I bid through some other company, then I said I will be trapped in that connected parties definition. So this is one of the most relevant aspect which one need to consider, and that's why this clause C also make it very clear that just because I'm the promoter of the corporate debtor, that does not stop me to propose a resolution plan if I'm not ineligible under 29C. So meaning thereby, if I'm not disqualified, if I'm not ineligible under 29AC, that just because of I'm the promoter, or just because I was the promoter, or just because I'm on the board, or just because I was on the board, or just because I was having a substantial control, or just because of I am having a substantial control over the corporate debtor share capital, that does not keep me out from the race of placing a resolution plan. I will be disqualified only and only in case if my own account is classified as an NPA at the time of submission of the plan, or the corporate debtor's account is classified as an NPA, and I am the one, the corporate debtor is under the management and control of my, I said the account of the corporate debtor under the management and control of such person, or of whom such person is a promoter, classified as an NPA, and 1 year is elapsed and I have not taken any steps. 1 year is elapsed from the date of such classification till the date of commencement of the CIRP. So plain reading is, at the time of submission of the plan, having an account or account of the corporate debtor under the management and control of such person, or of whom such person is a promoter, classified as an NPA. So this is the most relevant aspect as far as clause C is concerned. And many of the dispute rise from clause C, or many of the promoters are disqualified because of clause C, provided that a person shall be eligible. So this is the way government of India has identified through which some part of the NPA can be tackled or addressed. That I can back the eligibility back if I submit a plan after making this overdue amount of payment of interest, charges relating to NPA, and then if I am placing a resolution plan. But I said, when we deals with the connected parties, when we deal with the definition of the connected persons, it clearly states that person who is the promoter or the management or control, that is what we have seen. If a company is placing a plan, then the company's promoter or those person who are in the management or control, we need to check their eligibility. Person who shall be the promoter. So suppose if I'm bidding for a company which is in CIRP, and I'm bidding in a plan, I'm proposing a plan that this is what going to be a revival mechanism. This will be the persons on the board, or they will be the promoter, or they will be having the controlling rights over the company shares. Now, suppose if they are disqualified, and suppose if my company is placing a plan that in my company is holding subsidiary and associate company and related party to the persons referred in clause 1 and clause 2. But when an entity will not be, in spite of being seems, or in spite of being, or in spite of having the control over the company because of the shareholding, when a financial entity or when a financial sector, when an entity will not be treated as a related party, that is also provided that nothing in this clause shall apply to a resolution applicant where such applicant is a financial entity and is not a related party to the corporate debtor. Now, related party shall not include a financial entity regulated by financial sector regulator. If it is a financial creditor of the corporate debtor and is a related party to the corporate debtor solely on account of the conversion of debt into equity or instrument convertible into equity, or completion of transaction as may be prescribed prior to insolvency commencement date. Many a time it happens at the time of debt restructuring, when a company proposes to its financial creditor equity in lieu of the debt, and this is what provided. If the financial creditor of the corporate debtor is a related party to the corporate debtor solely on account of the conversion of debt into equity or instruments convertible into equity, or completion of such transaction as may be prescribed prior to the insolvency commencement date. Now, that does not stop my financial creditor to bid for my company, because they are related party only because of this debt restructuring. This is what explanation 2 states. For the purpose of this clause, where the applicant has an account or account of the corporate debtor under the management and control of such person, or whom such person is a promoter, is classified as an NPA, and such account was acquired pursuant to a prior resolution plan approved under the code, then provision of this clause shall not apply to applicant for a period of 3 years from the date of approval of the plan. So meaning thereby, I have acquired an entity during CIRP or through the means of CIRP. I have acquired an entity. I have purchased one company, or I bid for one company and acquired the company as a successful resolution applicant. Now, after getting this position in the corporate, or after getting this position in the company, that company was acquired pursuant to any approved resolution plan. Now, suppose I need to take care of that, being a new promoter or being a person or being a new person in the management, I need to take care of that. That situation should not subsist beyond 3 years. I know that I'm the one who acquired the entity and the status of the NPA was classified prior to my acquisition. Now, what I need to take care of is within 3 years, I need to make all the mistakes good, meaning thereby I have to clear the accounts of the company. And this is what explanation 2 states: for the purpose of this clause, where the applicant has an account or account of the corporate debtor under the management and control of such person, or whom such person is a promoter, classified as an NPA, and such account was acquired pursuant to a prior resolution plan approved under the code, the provision of this clause shall not apply to resolution applicant for a period of 3 years from the date of approval of the plan. Meaning thereby, if I'm the promoter, or if I'm on the board, or if I'm having a control over the company, and that company was acquired due through some CIRP means only, and because of that company was acquired through a CIRP, that company was ineligible under 29AC, but that was ineligible under 29AC, and thereafter I have acquired the same. But what I need to take care of is that disqualification will not attract only for 3 years post acquisition of that company through approved resolution plan. And after the completion of 3 years, I will be again, or I will be treated in equal footing with the other ineligible promoter which are defined under 29AC. And this is what explanation 2 all about of clause C of 29A. For the purpose of this clause, where a resolution applicant has an account or account of the corporate debtor under the management and control of such person, or of whom such person is a promoter, classified as an NPA, and such account was acquired pursuant to prior approved resolution plan under this code, then provision of this clause shall not be applicable to such resolution applicant. Now, Mary company, suppose if this company bids for other company in CIRP, I will be exempt, or I will be immune just for a period of 3 years from the date of approval of the plan, and not after that. So this is quite important, that even if you acquire a company under CIRP and you get a control over that company, if that company is ineligible under clause C of 29A, this ineligibility will not attract only for 3 years, and post 3 years you need to check whether
sign up karina.
Yes. Up to this extent, I would like to say, and I would like to invite, rather than, because this itself we are just on the stage 1, 2nd, and 3rd, but up to this extent, if there is something for the discussion, or if there is something for clarification, we can look into it, and then we will be proceeding further. So first, what we have seen is 29A clause, that is 29A clause A, and that is an undischarged insolvent, and that is what I said, part 3 of the code, when it is going to be applicable for an individuals also. Then what need to be seen is whether any repayment plan is approved by the COC or not, or whether a person has got a discharge order or not. If not, then I will not be treated as eligible under 29. Another one is list of willful defaulter you need to check when a person is proposing a resolution plan. Most crucial was C, and this is what I said, that there is a myth that just because I was the promoter of the company, or just because of I was the promoter of the corporate debtor, that does not debar me to propose a plan. Suppose if I'm not at all disqualified, neither my account was classified as an NPA, not the corporate debtor's account was classified as an NPA, or suppose if I was on the board of that company, but it was long back before the commencement of CIRP. Now, suppose if myself is not disqualified at the time of submission of the plan, then in that case, just because I'm the promoter, or just because I was on the board, or just because I was holding the controlling interest in the company, that does not stop me to propose a plan. I will be ineligible only in circumstances if at the time of submission of the plan, my account was classified as an NPA, or account of the corporate debtor under the control and management of such person, or of whom such person is a promoter, classified as an NPA in accordance with the guidelines of the RBI under the Banking Regulation Act, and 1 year has elapsed from the date of such classification of the account till commencement of the CIRP. And this is what I said. This is the step which the government has taken. This is brought in with an intent to clear the maximum NPA, that if I'm intending to propose a plan, though I'm disqualified, or those I'm ineligible under 29AC, but if I make a repayment, there is a time frame of 30 days which is provided, and this 30 days will not give you an extension in CIRP. This 30 days is inclusive of 30 days 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 of that 180 days or 270 days. So if I clear that amount, if I make the payment of that overdue amount with interest and with all the charges relating to NPA, before submission of the plan, I will get my eligibility back. And I said, this layer 1, layer 2, and layer 3. That means I need to see whether my eligibility is, or whether I am eligible or not. I need to see the connected persons. I need to see the related parties to that connected person. But in that circumstances, just because of a financial creditor is bidding for a company and that financial creditor is treated as a related person because of the substantial shareholding in the company, will not be treated as a related party if a financial entity is a financial entity regulated by the financial sector regulator. It is the financial creditor of the CD and related party solely because of the conversion of that debt into equity. That does not make that financial entity, though the financial entity is holding majority of the share, ineligible under 29AC. And one thing is very, very clear, that a company is bidding for a company in CIRP. A company is placing a resolution plan for a company which is in CIRP, but that company was acquired. The company which is proposing a resolution plan, that company per se acquired through CIRP means, through approved resolution plan, that disqualification will not attract under 29AC for 3 years. And post 3 years, it will be parallelly competing with the other entities for which, or the other person for which 29AC is applicable. For the purpose of this clause, where a resolution applicant has an account of the corporate debtor under the management and control of such person, or whom such person is a promoter, classified as an NPA, and such account was acquired pursuant to prior resolution plan approved under the code, the provision of clause 29AC shall not apply to such resolution applicant for a period of 3 years from the date of approval of the plan by adjudicating authority under this code. I would like to give a participant a reason to throw a light on it in case if they came across any practical difficulties, or there are certain things which requires to be discussed out of clause A, B, and C of 29.
Sir, you had mentioned about MSME relaxation, sir.
Yes, sir.
Can you just throw some?
We will be reaching to 240A shortly, sir. We will
Fine,
be
sir.
reaching to that part.
Thank you. Thank you.
Yes, sir. And we will be dealing into one of the judgment of Supreme Court. Our institute's member, Hari Babu Tota, that's from Bangalore, who contested this matter up to Supreme Court, and Supreme Court has made the things clear that the eligibility of the promoter of MSME will be looked into at the time of submission of the resolution plan. So we will be dealing into that judgment of Supreme Court in case of Ashraya. Hari Babu Tota was the RP of that. So we'll be dealing into 240 aspect, but up to this extent of 29A clause ABC, if there are certain things for a discussion, we can have a discussion on that aspect before dealing into clause D. Now this is clause D, this 29A clause D, which states that now make sure the D and E clause which we are going to discuss, clause number D of 29A and clause number E of 29A will not having its root up to connected persons. So for A, for B, for C, I said you need to have a multi-layered due diligence. You need to have a due diligence for the person who is placing a resolution plan. You need to keep a due diligence open for the connected persons, and you need to keep a due diligence for the connected persons related parties. But as far as clause D or clause E, which we are going to discuss upon, that shall not extend to connected persons. D is talking about convicted for any offense punishable with imprisonment. So there is a 12th schedule which is provided under this code. There is a 12th schedule which is provided under the code, and there are certain acts which are provided. Now this is 12th schedule, section 29A clause D, which deals with certain acts, RBI Act, Central Excise Act, Prevention of Food Adulteration Act, Essential Commodities Act, and there are number of acts that is up to 25, including Insolvency and Bankruptcy Code, including Companies Act, including LLP, including Competition Act. So in that case, if a person is sentenced for an imprisonment, दोषी ठहराया गया हो, if a person is sentenced for an imprisonment for a term of 2 years, it is provided in clause D. I'm reaching out to that. This is clause D of 29A. Person has been convicted for an offense punishable with an imprisonment of 2 years or more. For a 2 years or more under any act specified in 12th schedule of this code. And if a person is sentenced for an imprisonment of for 7 years or more under any other law for the timing in force. So you need to see if a person is convicted for an offense punishable with imprisonment for a term of 2 years or more under any act specified in 12th schedule, 7 years or more under any law for the timing in force which are not there in 12th schedule. In that case, the person will not be considered eligible to place a resolution plan. But yes, post expiry of 2 years from the expiry of a sentence, this clause shall not be applicable to the person after expiry of after an expiry of the period of 2 years from the date of his release from imprisonment. So I said, after the expiry of the sentence, saja समाप्त होने के बाद 2 सालों तक, shall not apply to a person after expiry of a period of 2 years from the date of his release from imprisonment. 2 years from the date of release of this imprisonment, up to 2 years, I will be treated ineligible under 29 AD. But that ineligibility will go away on expiry of 2 years from the date of my release from imprisonment. So this 2 years or more under any act specified in 12th schedule of the code, 7 years or more under any law for the timing in force, I will be treated as ineligible, and I will be treated ineligible even after my release for a period of 2 years. But this particular clause D shall not apply in relation to a connected person referred to in clause 3 of explanation 1. Connected persons referred to in clause 3 of explanation 1. We will be dealing into that again. That will not extend. Related party of the persons referred to in 1 and 2. So if a person himself is ineligible under clause D, that ineligibility will only extend up to the person who intends to propose a plan, and this ineligibility will not reach to the related party of that connected persons or related party of the persons referred to in clause 1 and 2. This is clause D. Now clause E, which talks about the disqualified to act as a director under the Companies Act. Now there is a lack of clarity in this connection, because when you see a disqualification to act as a director under the Companies Act, there is a provision of section 164(1), 164(2). Now, who will determine the disqualification? That is a big question. Who will adjudicate upon whether a person is disqualified or not? Because many a time it happens. For example, there is a provision of section 164 subsection 2 which states that if a company has not filed its annual return or a financial statement, or company has not repaid its mature deposit, or company has not declared, or company has not paid dividend even after the declaration of the dividend at the AGM, or company has not repaid its mature debentures or redeem its mature debentures or deposits. Now, who is going to take care of, or who is going to qualify or disqualify him? That is my question. Now, this is something, because 164(1), if you see, there is a disqualification order passed by a court or a tribunal. But by the virtue of the Companies Act, by the virtue of the provisions of the Companies Act, there is a disqualification which is provided under section 164(2). But I said, if there is no order which is passed even after this disqualification under 164(2), whether the person will be treated as eligible or whether that person will be treated as ineligible, that is something for which immense clarity is required from the NCLAT or at the end by the Supreme Court. Disqualified to act as a director, because when you see a disqualification provisions of the Companies Act, it is having its layer in 164(1) and 2. Anything to discuss upon? The provision on 164, there is a provision of 164(2) says, if a person functions as a, that is subsection 2, which states that not filed the financial statement or annual return for continuous period of 3 financial year, or has failed to pay the deposit accepted by it or interest thereon, redeem debenture or interest thereon, or pay dividend declared, and such failure to pay or redeem continues for 1 year or more, there is no authority to mark him disqualified. Now, at the time when you check yourself the eligibility, are you going to consider, suppose if a person is proposing a plan, if that person is also holding a directorship in one company and that company has not filed return since 3 years or 4 years or 5 years, by the virtue of this act, he is disqualified. But he is not disqualified by the order of any court or tribunal. Now, the question that arises, that whether to consider him eligible under 29A clause E or not. So that is something which is quite, because in the interaction, see, there were the list of disqualified director which was published in the MCA portal. Now, many a time it happens, the name of person is not there in that list itself. The name of person, after extensive search, if the RP has failed to identify his name in that list, but prima facie is a disqualified because of being a person on the board of that company who has not filed the return since years. Or in spite of this fact that company has declared dividend, but that dividend is unpaid. But there is no tribunal or court which has passed any order against that person for the disqualification, whether I'm going to treat him as eligible or whether I'm not going to treat him. That is something which is one of the question which the judiciary or which the adjudicating authority has to decide when dispute arises in this regard. So this is 29A clause E, which talks about disqualification to act as a director, and this is also one of the ineligibility which will only extend to the person who is proposing a plan, and it will not apply in case of connected persons. So this clause D and E, D which deals with conviction for any offense punishable with an imprisonment of 2 years or more under the act specified in 12th schedule, 7 years or more under any other law for the time in force. And as far as the E is concerned, it talks about disqualified to act as a director, but it will not extend to the connected persons referred to in clause 3 of explanation 1. We are up to this extent. Another one is the F. Section 29A clause F, prohibited by SEBI from trading in securities or assessing the securities market. But there is no privilege to the connected persons in this case. There is always a provision which insider trading, which do have its extension up to all the connected persons acting in concert. So if a person is prohibited by SEBI from trading or dealing in the securities or assessing the secondary or securities market, in that circumstances, that persons will be considered ineligible by the virtue of 29AF because of being prohibited by the SEBI from trading in the securities or assessing the securities market. Now, this is very, very much, you can say, this is something which require a thorough understanding. Now, there are transactions. Now, suppose if a company is a corporate debtors promoters are intending to propose a resolution plan and section 43 or 66 application is pending. If order is not passed, is altogether a separate issue. But if the order is passed, then it will make me ineligible to propose a resolution plan. Even though I am eligible under 29AC, but this clause G is very relevant. Has been a promoter or in the management or control of the corporate debtor. Has been a promoter or in the management or a control of the corporate debtor in which preferential transaction or undervalued transaction or extortionate credit transactions or a fraudulent transaction has taken place, and in respect of which order has been made by adjudicating authority under the court. Now, this is something. There was an order passed by the adjudicating authority under this code, and the order was related to a PUFE transaction, preferential transaction or undervalued transaction or extortionate credit transaction or fraudulent transaction, and that was taken place. An order was passed by the adjudicating authority under this code. In that case, suppose if those persons who were involved in those transactions, if they are intending to propose a resolution plan, they will not be considered eligible. Or suppose if that company intends to propose a resolution plan against which an order was passed under this IBC with respect to preferential or undervalued or extortionate or fraudulent transaction, then in that case, they will not be treated as eligible. But many a time it happens. The same thing which applies in this also, that I have acquired a company through CIRP, being a resolution or being a successful resolution applicant, I have got an entity. In that entity, these transactions were identified and order was passed against that entity. But I have got the entity through approved resolution plan. In that case, there were transactions which were undertaken in that entity, that preferential or undervalued or extortionate or fraudulent transaction that were taken place, but I was not a contributory to those transactions. I have got this company through the code. I have got this company through a resolution plan duly approved by the adjudicating authority. And presently I am the owner, or presently I am on the board, or presently I am in the control of that company, or presently I am the promoter of that company. Though there was an order passed with regards to this company, but that will not make this company disqualified or ineligible to act as a resolution applicant, and that clarity is provided. That clarity is provided in this proviso, which states that this clause shall not apply if preferential transaction or undervalued transaction or extortionate credit transactions has taken prior to the acquisition of the CD by the applicant, pursuant to resolution plan approved under the code, or pursuant to the scheme or plan approved by the financial sector regulator or court, and such resolution applicant has not otherwise contributed to those transactions. Today, the company which is bidding as a resolution applicant is a company which was acquired through a means of CIRP. Now, against this company in the past, some order was passed by the adjudicating authority. That does not mean that the present resolution applicant is ineligible, because considering the fact that the present resolution applicant is not a reason for those transactions which were undertaken or which were there in the past in the company, because since I have got this company in a clean slate manner, I have got the resolution plan approved in my name by the COC, by the adjudicating authority, irrespective of the fact whether any order was passed with regards to this company under this transaction or not. But since I as a new face, or I as a new promoter, or I as a new management, if proposing a plan for some other company, one cannot come in my way and say that since you were the company or there was an order passed against your company under section 43 or 66 and that keeps you or that makes you ineligible, that cannot come in my way, just because of the fact that I was not the one who was the contributory to those transactions. Though the transactions were there in the name of company, but the promoter or the management or the controller of those company are not the one who are right now controlling or promoting or managing the affairs of this entity. So this has made the things very clear that this clause shall not apply. If a preferential transactions or undervalued transactions or extortionate credit transactions or fraudulent transaction has taken place prior to acquisition of the corporate debtor by resolution applicant. Prior to acquisition of the corporate debtor by applicant, pursuant to plan approved under the code, or pursuant to scheme or plan approved by financial sector regulator or court, and such applicant has not otherwise contributed to those transactions. In that case, just because of the name of the entity which was involved, that does not make this entity ineligible, because now the entity is being controlled by the new faces. This is quite relevant as far as 29AG is concerned. This is very important. And that's why many a time it is seen that the resolution plan which is put forth by the promoters gets noted by COC and gets assent by the adjudicating authority. And I've seen many resolution professionals who once moved an application under 4366 used to withdraw that if it is not reaching. And so basically it is a discretion of the applicant to withdraw the application also. Now, this is clause H, a very recent ruling of the Supreme Court in this connection. I have given a guarantee. I have given a guarantee on behalf of a corporate debtor in favor of its creditor. Executed a guarantee deed in favor of a creditor of the corporate debtor. Now this things are, or this ambiguity is very clear. Suppose if I'm a person who extended a guarantee on behalf of a corporate debtor in favor of its creditor. Now suppose if that corporate debtor fails to make the payment to that creditor, the creditor may invoke a guarantee. And after invoking the guarantee, now suppose if being a guarantor, if I fails to make the payment, whether in full or in part, if I fails to make the payment, whether in full or part, so guarantee is invoked and the corporate debtor has committed a default, and thereafter the default was committed by a guarantor also. Though I extended a guarantee, but even after the invocation of the guarantee, that amount is unpaid, whether in full or in part, then irrespective of the fact whether the same creditor has moved an application against the corporate debtor or some other creditor, it will make me ineligible under 29A clause H. Executed a guarantee. So I'm the person who is intending to propose a plan, and I had executed a guarantee in favor of a creditor in respect of the corporate debtor against which application for insolvency resolution is made by a creditor is admitted under the code, and such guarantee has been invoked by the creditor and remain unpaid in full or part. So there was an ambiguity as far as the language of this clause H is concerned. Clause H talks about executed a guarantee in favor of a creditor in respect of the corporate debtor against which an application for insolvency resolution was made by such creditor has been admitted. So there was an ambiguity. The same creditor in whose favor I have extended a guarantee, that creditor has moved an application against the NCLT for initiation of CIRP, and that application is admitted. The Supreme Court has made it very clear, irrespective of the fact whether that creditor has moved an application or some other creditor has moved an application. But the fact is, if the corporate debtor is under CIRP or any of the creditor has invoked the guarantee, and even after the invocation of the guarantee, if the amount is unpaid, whether in full or in part, if the amount is unpaid, that will make me ineligible, disregarding the fact whether the creditor in whose favor the guarantee was extended, whether that creditor has moved a CIRP application or some other creditor. But what need to be taken care of is, if I have given a guarantee, that guarantee was invoked, and even after the invocation of the guarantee, if I have failed to make the payment, whether in full or in part, and if the corporate debtor is in CIRP, I will not be treated as a person eligible to propose a plan. Reading it for the sake of the convenience of the participant again. 29A clause H. Executed a guarantee in favor of a creditor in respect of a corporate debtor, or in other language, executed a guarantee on behalf of CD in favor of its creditor, against which an application of insolvency resolution was made by such creditor. So confusion is because of the word such creditor. So basically, prior to the Supreme Court judgment, there was a challenge that the condition is the creditor in whose favor the guarantee is given, that creditor has made an application against the corporate debtor for initiation of CIRP and that application is admitted. But Supreme Court has made it very clear whether this creditor has moved an application or some other creditor of the corporate debtor has moved an application. That is not the crux of the code or the intent of bringing this clause in the code. The crux is the guarantee is invoked and you have failed to make the repayment in full and part, and the CD is already admitted in CIRP, you will not be treated as eligible if guarantee was invoked by the same creditor who moved an application of CIRP or some other creditor of the corporate debtor. But any of the creditor who invoked the guarantee, and even after the invocation of the guarantee, the amount is unpaid in full or in part, then you will be considered ineligible under 29A clause H. This is 29A clause H. This is something, if it is required to be discussed, it will be rediscussed again. And this is clause number I as stated earlier.
Can
Yes.
can I add something?
Please, sir, please, sir, please, sir.
So if a financial creditor invokes, or if the financial creditor or any other financial creditor has initiated the insolvency resolution, then he is ineligible. Suppose the application is made by an operational creditor, then?
See, in that case, how come? The important thing is, first thing you need to take care of is whosoever has moved an application. Whosoever has moved an application, if the company is in CIRP, the important thing is a financial creditor in whose favor the guarantee is extended. In whether in favor of a sole financial creditor, in favor of any consortium, or more than one secured lender of the corporate debtor. If those financial creditor or any of the financial creditor has invoked the guarantee, even after the invocation of the guarantee, if I fail to make the repayment in full or in part, that straight away make me ineligible, disregarding the fact whether the application under this particular code is admitted by an application of a financial or an operational. The ambiguity was with regards to the term such. So there was an understanding that I committed a default in making a payment to the same creditor who invoked the guarantee, and that creditor application was admitted by the NCLT. But that such will keep all the secured financial creditor parallelly. So whether I extended guarantee in favor of the same financial creditor who moved an application or some other financial creditor, but the important is if that company is in CIRP, guarantee is invoked, even after the invocation of the guarantee, the amount is unpaid.
So I can interpret it that way, that if the application is even initiated, the CIRP is initiated by the operational creditor, then also I am ineligible if I have given the guarantee.
Yes, because see, in this case, the extent is only up to this, that executed a guarantee in favor of the creditor. The word is creditor.
Got it. Thanks.
Now coming to the another part, that is 29A clause I. And clause I is very clear at the beginning itself. It was very much clarified that persons means any person. So it also includes a person who is residing out of India, but a person is disabled, ineligible due to corresponding clauses of A to H under any law of his home country, then in that person, in that particular situation, that person will not be treated as, and this makes a person's RP's role or RP's position very difficult, because here he need to take a due diligence with the assistance of a person or the professional of that country from which the resolution applicant belongs. So this is something which I would like to say. Here you need to completely rely upon a advocate or the lawyer or a practicing professional into the insolvency law of that country from where the resolution applicant belongs and tendering a resolution plan. J is something which is already made very clear that has a connected person's knowledge and is eligible under A to I. But in that A to I, the exception will remain as a D and clause E. D, which talks about convicted for an offense punishable with imprisonment, and clause E deals with a disqualification to act as a director. For this particular clause D and clause E, the explanation, the connected persons whose reference is provided an explanation shall not apply in case of a related person. So in case a person is convicted for an offense punishable with an imprisonment of 2 years or more under any of the act specified in 12th schedule, 7 years or more under any law for the time in force, then this clause shall not apply to a person after the expiry of 2 years from the date of release of imprisonment. But this proviso is making it very clear that this disqualification or this ineligibility shall not apply in relation to a connected person referred to in clause 3 of explanation 1. Same thing is also going with clause E of section 29A, disqualified to act as a director. And it is also making it clear that this clause shall not apply in relation to connected persons referred to in clause 3 of explanation 1. And we again would like to keep a view on, or we again would like to have a look into this explanation 1, connected person. And as far as connected person is concerned, I said, if a company is proposing a resolution plan, if a LLP is proposing a resolution plan, if a person is proposing a resolution plan, then connected person's definition will extend to a company is proposing a plan, for example, or the LLP is proposing a plan. Then in that case, the person who are the promoter of that company and LLP, you need to see all the ineligibilities for those persons who are the promoters of the company or the LLP or other body corporate, those who are in the management or control of that resolution applicant. So as I said, if a company is proposing a plan, then I need to see into the disqualification, or I need to see into the eligibility or ineligibility from the viewpoint of the persons who are on the board, who are in the management, the persons who are the promoter, or the persons who are holding the shares, having a control over the company. Not only this, if I'm proposing a plan for a corporate debtor and I'm mentioning in the plan that this is going to be the proposed structure of the board, or this is going to be the proposed shareholding pattern. So the whosoever is going to be the promoter of that company, post approval of the plan during the course of implementation, whosoever is going to be on its board, or whosoever is going to control the company qua shareholding, that person's ineligibility you need to look after. Company is proposing a plan, I need to look after the eligibility of the holding, my subsidiary, my associate. And not only this, I need to check the related parties of the persons which are there in clause 1 and clause 2 of this explanation 1. So this is something which is quite crucial for sake of due diligence, or it is quite crucial when you play your role as a resolution professional and giving your views to the committee of creditor pertaining to the eligibility of the resolution applicant who has submitted a resolution plan. Just for the sake of the final view on the subject or on the topic, the intent of the code is very important. Those who have contributed to that situation, those leading to which the company, the corporate debtor, has reached to the stage of CIRP, those who are the reasons for that corporate debtor's account to be classified as an NPA. The act made it very clear, because see, this 29A is something which was made effective through an amendment, and that was November 2017, 23rd November 2017. It was through an amendment the section was brought in. Otherwise, the intent of the code was not fulfilling its purpose. You cannot give a backdoor entry to the same face those who have brought in the situation for a company which is facing right now in CIRP. So ultimate intent is you cannot bring those persons back who were actually the contributory to a situation for a corporate debtor facing CIRP. That was the ultimate intent of 29A. Now, as far as this 29A is concerned, we need to see from RP's viewpoint under section 30. And when you see the provision of section 30, it clearly states that the committee of creditor may approve a resolution plan by a vote of 66% voting share of the financial creditor after considering the feasibility and viability, the manner of distribution proposed, which may take into account the order of priority, including priority and value. But this is very important, that committee of creditor shall not approve a plan submitted before the commencement of. So it is having its wings with a retrospective effect, where a resolution applicant is ineligible under 29A and may require resolution professional to invite a fresh resolution plan. So this is for those entities where the resolution applicant was ineligible, even though the EOI was submitted prior to the enactment or prior to the notification of 29A, but subsequent upon notification of 29A, suppose if that resolution applicant is ineligible under 29A, in that case, the code mandates RP to invite a fresh plan if no plan is available with it. Where the resolution applicant referred to in the first proviso is ineligible under 29AC, this is what I was talking about. The C, which talks about if my account was NPA, or if I'm the person who was in control of the corporate debtor, or who was in the management of the corporate debtor, or who was the promoter of that corporate debtor, whose account was classified as an NPA at the time of submission of the resolution plan, then it makes me ineligible to tender my plan. But I said the act allows me, or act gives me an opportunity to make myself eligible, and this is what that sub proviso is. Where the resolution applicant referred to in first proviso is ineligible under 29AC, the resolution applicant shall be allowed by the committee of creditors such period not exceeding, and this is shall be allowed by the COC, shall be allowed by the COC, put an obligation on the COC to consider and give me a period of not exceeding 30 days to make the overdue amount in accordance with the provision of 29AC, and I will be again eligible to tender a resolution plan. One more thing need to be taken care of, and that is 35, section 35(1). Section 35 is talking about a liquidation, and that clearly states that during the course of liquidation, the liquidator is not allowed to sell the immovable or movable or any actionable claims of the corporate debtor in liquidation to any person who is not eligible to be a resolution applicant. It is having its root to all the extent, and act clearly debars such persons who are responsible or who are contributory to a position which the corporate debtor is facing, to keep the corporate debtor away from such persons, leading to which the corporate debtor is facing the situation of CIRP. So this is what in section 35 also it is provided, that liquidator is again need to be very cautious while selling the properties of the corporate debtor, including actionable claims of the corporate debtor in liquidation, if the sale is being made to a person who is not eligible under 29A of the code. Apart from that, there is a regulation also which mandates RP towards his duty to take care of before proposing or before tendering the plan before the COC. I'm just sharing the regulations in this regard. Insolvency and Bankruptcy Board of India Insolvency Resolution Process for Corporate Persons Regulation. I'm just sharing the regulation for the sake of further understanding pertaining to the role of the RP. That is regulation 36A. This is what we were discussing about the information memorandum, and after that invitation of EOI. And this is what provided at the time when the RP invites an expression of interest. He need to be very cautious while inviting a resolution plan or prospective resolution applicant. They specify the criteria for prospective resolution applicant as defined under 25(2)(h), state the ineligibility norms under 29A to the extent applicable for prospective resolution applicant. The expression of interest shall be unconditionally and be accompanied by an undertaking. So suppose if I'm the investor intending to propose a plan, and when I submit my EOI, there is an obligation on my part to give an undertaking to prospective. I said it is an obligation on my part to give an undertaking to the effect that I does not suffer from any ineligibility under 29A to the extent applicable. Now see, the resolution professional shall conduct the due diligence when the final list of resolution applicant, the eligible resolution applicant get finalized. It casts an obligation at that level also, at that layer also. You will get a resolution plan later on. First, you need to identify the prospective resolution applicant, and you need to have your due diligence at that stage itself. The resolution professional shall conduct due diligence based on the material on record in order to satisfy that the prospective applicant complies with 25(2)(h) and applicable provision of 29A. This is what 36A all about. And when you see regulation 39 also mandates that affidavit stating that it is eligible under 29A. It is an obligation on the part of the applicant, but vis-a-vis, it is the RP who need to undertake due diligence whether the criteria of 29A is being complied or not. And similarly, similar provisions are there when you go into the liquidation regulation. And this is what, as a matter of fact, known to everybody, that every attempts are made to bring the corporate debtor back on its feet by the way of the provision of section 230, 232 of the Companies Act. But again, that scheme of compromise and arrangement you are not entitled to propose if it is decided by the committee of creditor to give an option, or it is decided by the committee of creditor to opt for the scheme of compromise and arrangement, but one who is tendering or one who is sponsoring the scheme of compromise and arrangement before opting for a liquidation, if they who are proposer of the scheme, if they are proposing a scheme, but to the contrary, if they are not eligible under 29A, they are also, because see, the object of the code is going to be defeated if it will kept open for the promoter to bid under 230, 232 of the code, which deals with the compromise and arrangement, which may be by the way of merger or amalgamation or any debt restructuring scheme, which requires the approval of the creditor, majority holding 3/4 in value of the creditor. But in case if that will be kept open, and if 29A ineligibility will not be applicable to them who are the sponsor to the scheme of compromise and arrangement, then purpose of 29A will be defeated. So those who are not, or those who are ineligible under 29A, they will be seeking another opportunity through the scheme of compromise and arrangement. And that's why when you see the liquidation regulation has made it very clear that if the company goes into the liquidation, then you need to check the one who is proposing a scheme of compromise and arrangement. They should not be the one who are ineligible under 29A. And that is what you will find in regulation 2B, compromise and arrangement, where the compromise or arrangement is proposed under section 230 of the Companies Act. It will be completed within 90 days of the order of liquidation under section 33, provided that who is not eligible under the code to submit a plan for insolvency resolution of a corporate debtor shall not be a party to any matter to such compromise and arrangement. So things are very clear that disqualification, or rather calling it disqualification, the ineligibility criteria for a resolution applicant, which is defined under section 29A of the code, is having its extent much beyond the completion of CIRP. Suppose if there is a failed CIRP and corporate debtor is dragged to its liquidation, but it is a collective decision of the COC to opt for a compromise and arrangement. It is what provided. There is a time frame which is provided that it should be completed within 90 days from the order of liquidation, which is practically not possible. But a person who is not eligible under 29A to submit a plan for the CD shall not be a party in any manner to the compromise and arrangement, so that the purpose of bringing 29A should not be defeated. This is the only purpose. I would like to have your questions in between before we deal with few of the judgments of the NCLAT and Supreme Court with regards to 29A. If there are certain things for a discussion, we should take that into priority before going into few of the decided rulings of the Honorable Supreme Court and the NCLT. The layer is quite important, and that is what I said, that it is having its shells. One who is proposing a plan, if a person is proposing a plan together with some another person, you need to check the eligibility of the person who is jointly at the co-resolution applicant's eligibility. You need to go much beyond that, because it talks about a connected persons, and when you see a connected persons, then basically you should see from the viewpoint of a body corporate proposing a plan, and you need to see the ineligibility or the eligibility criteria of that body corporate's promoter, that company's management, those who are in the management of that company, those who are the promoter of that company, those who are in the control of that company. And you need to check their related parties also. You also need to check the one whose name is being proposed in the resolution plan, that this shall be the promoter, or they will be in the management, or they will be the controller who are shareholding in the company. You need to check, are they eligible under 29A? Because everything is fine and everything is decided up to the level of approval of the plan, but you are proposing the name of those persons in the resolution plan, that this corporate debtor is going to be under the control of this management, or this will be the promoter who is going to run the operations while execution of the resolution plan, or this are going to be its shareholder. If they are ineligible under 29A, it will make your purpose futile of proposing a plan. And similarly, whosoever is the entity proposing a plan, you need to go into the roots of its subsidiary, its associate, its holding company, and you need to check the promoters, the management, the controllers, related parties. So I would like to say it is having its own reach, it is having its own extent, or it is having its own roots, and you need to see the ineligibility criteria from all these viewpoints. The persons proposing a plan in jointly with some other persons, his ineligibility. You need to check the connected parties. You need to check the related parties to those which are defined in clause 1 and 2 of that explanation to connected parties. Yes.
Hello, sir.
Yes, sir.
Hello, sir. Sir, VBS ready?
Yes, sir.
Hello.
Yes, sir. You're audible.
Where 29A complaints to be done by RP, where it is mentioned in the code or regulation?
So you mean to say that where it
whose
is
responsibility?
stated,
Yes, sir. Yes, it is
is
whose
the
responsibility? Responsibility
just-
RP. Where it is mentioned?
again, when you see the Supreme Court ruling of the SR Steel,
Okay, sir.
I'm just sharing the content. I'm just
Okay.
sharing the content
Ah,
which deals with that aspect of your question, that how come it will be considered as a duty on the part of the RP. Now the
Yes,
question is, if not RP,
Huh.
then who will be the persons responsible for its cross verification? I'm just asking this
COC.
question.
COC.
No. You cannot expect COC to play the role of the RP, because it is me who need to put a proposal before the COC. It is not the resolution
Yes, sir.
applicant who is tendering the plan before the COC. Tomorrow the COC will held
Okay.
responsible that RP's lack of diligence or due to non-completion of the due diligence, or because of the recklessness on the part of the resolution applicant, we came to know later on that he is not eligible under 29A. Let's see, because among COC there will be further conflict that who will taking a lead. There will be a varieties of views, or there will be a variation of the judgments. Now let's see where it is provided that it is the responsibility on the part of the RP. Is it visible now?
Yeah.
I'm just sharing the most relevant part. The most recent judgment dated October 4, 2018. It is no more a recent now. But yes, it is talking about the same SR judgment. The Supreme Court explained and reinstates the importance of conducting a thorough due diligence under 29A. As noted by Honorable Supreme Court of India, great care must be taken to ensure that person who in charge of the corporate debtor implies RP, for whom such resolution plan is made, do not come back in the same. And that is talking about the promoter. So who are in charge of the corporate debtor from whom such plan is made, do not come back in some other form to regain the control of the company without paying off its debt. Now coming back, I'm just sharing the regulation.
Sir, you can
Yes, sir.
show me later also, sir. No urgency. We'll see later. No problem.
No,
sir.
we can check,
Understand.
because it is, let's because we are on the very correct point that where it is provided that onus will be on the part of the RP. Because the question always arises that if not RP, then who will be responsible for the statement?
Argue. It is not your responsibility. I certify that it is a 29A complaint. You pass the resolution. All COC people will talk like that one.
Because right now, when the company is in CIRP, there is always an obligation and onus which is coming on my way, that whatever I'm going to tendering before the COC will be looking after the commercial wisdom, or rather calling it a commercial wisdom, they will be looking after how their purpose is being resolved through that tendered resolution plan, and they will be taking, or they will be accordingly taking a decision. They are rather not concerned for that eligibility or ineligibility. They are concerned for ineligibility only when they are dissenting to any plan.
नहीं नहीं ऐसे कुछ देखा तो नेमी का फोन आया था क्या आ रहा बोल के।
Here it comes, sir. Here it comes. And we are dealing into this regulation 36A. This regulation 36A, subregulation 8, which makes it very clear that RP shall conduct due diligence. Of course, based on the material on record, in order to satisfy that the prospective, this is coming far before the proposal of the resolution plan. It is a stage wherein a person is submitting its EOI. And it is the RB who should conduct, and you need to attach a copy of the due diligence report. Based on the material on record, in order to satisfy that, the prospective resolution applicant complies with the applicable provision of 25A. This is something wherein I would like to say that it is going to be a comprehensive search. Being an RP, I need to go into that, or I need to dwell that whether the condition of 29A is being actually fulfilled, and it will not merely be relied upon on the basis of the declaration which they have given, or on the basis of the affidavit which the person has given. To go into the verification of this affidavit stating that an applicant is eligible under 29A, that casts a duty on the part of the RP. We will be checking, because that will be coming on our way also, because I have taken the extract of the judgment of the Supreme Court in this connection. And we will be dealing into that aspect of Swiss Ribbon as well as this SRN Satish Kumar. But yes, it is very well falling under the responsibility on the part of the RP during the course of tendering a plan to check whether the criteria of eligibility under 29A is being complied by the RA or not. So I'm not dealing into the background. Yes, sir.
One more question.
Yes, sir.
Father was a director and borrower in another company. He borrowed and the account became NPA and all those things happened for father. Son became a resolution applicant for one company. Son has never borrowed, our accounts became NPA, and he is not involved in all PUFA transactions of father. And he brought one separation letter, partition deed from father. I am independent. I am doing my own business, like that. In that case, how to deal the situation, sir?
When the separation was done.
No, there
my
is
question is,
the
separation you are talking about between a father and son.
Yes, sir.
When
Partition.
that separation has actually taken place.
That happened more than 1 year before submitting the resolution plan.
Okay. And during the course when that PUFA transaction, because there is no look back period to the fraudulent transaction.
Correct.
So in that case, whether the separation was prior to those duration when the transactions were identified. Now this is a question.
Next,
basically, no, he will not be eligible, and he will not be considered as eligible to move a resolution plan before the adjudicating authority, considering the fact that being a related party, a person who is not eligible and I being a related party to the person who is not eligible, that does not make me eligible on the basis of that separation or that certificate of separation, or on the basis to demonstrate that I'm nowhere connected to the persons who is ineligible. And it is again important that during those days when those transactions were undertaken, whether I was a related party or not, if I was a related party, directly it will make me out from the domain of eligible persons under 29A, or it will make me disqualify under 29A.
Sir, just to supplement Mr. Reddy's question, you go one step further. Now, father is doing business, son is an insolvency professional. we have this code of ethics now for insolvency professionals.
Yes, sir.
You should not get yourself involved in business. They'll host of, just like how we have for chartered accountants. So there itself it gets defeated, sir. Let us not go to the next step. This is my view. See, by virtue of his father doing business, he cannot be a partner in that business if he's an insolvency professional.
This is all together, yes. So
Yeah.
Yes, sir.
considering the fact if he's an insolvency professional, it will always
That is what he has said, sir.
going to
What
be
Mr.
considered
Reddy
as
said
yes,
was
yes,
that.
Sir,
yes, I missed that
There
particular
itself it
thing,
gets
but yes,
defeated.
if
Sir,
he
one
is an
minute, sir.
insolvency professional, it will
No.
always consider as a direct conflict of interest.
Yes,
conflict.
yes,
Correct.
yes.
Sir, some more information. When father was doing business, when he was borrowing, he was doing transaction, the son was a minor. Son was a minor. So
Okay.
now after he became major, he started his own and he got separated.
Mhm.
Now all those transactions, father against father, those things are happening.
Mhm.
Son says there is a separation or partition deed duly notarized that happened long back, like that he has brought.
Sir, who's going to inherit? You take a converse situation. Now business is at a loss. The business is at a profit. Post the father's demise, who's going to who's going to inherit this property or this profits? This is what the question the coach will ask. This is my view, sir.
Correct, sir. You are correct, sir.
Yeah.
You are correct. Old. But
and as far as his minority or age will not come in between when we see a definition of related party.
And I checked all buffet transactions, whether this fellow son has become any party, any of the transactions. Nowhere his name is mentioned.
No.
Transaction.
Though there is a case wherein he is not engaged in any of the transactions.
Okay.
He was not involved in a buffet transactions, but extent of this definition or extent of this explanation of that connected person, that person per se will be considered ineligible.
Sir, both are living separately. Both are living separately. Separation deed is there. Like let us go to Anil Ambani and Mukesh Ambani. There also they got separated. And Mukesh Ambani acquired the assets of Anil Ambani. Both are brothers. Both are correct, sir.
See, in that circumstances, I must say
brothers, sir. Here, this is father and son.
Father and son. Agreed.
Yeah.
No, again, even if it is a brother, it will again squarely falling under the definition of that
related party.
Related
party. Both are same. Related party, both are same.
Correct.
Yes, sir.
See, as far as the intent is concerned, I would like to say the intent or the purpose of 29A will be looked into. Right.
Sir, sir, intention, there is no problem with the intention.
No, correct. Now you are demonstrating the fact that we are not related party in spite of being a related party by the virtue of definition. But we were not connected, or there was no business relationship, or I was not a contributory to that situation, which was emerged because of the conduct of my father.
This is not to acquire their company, to acquire the different company.
Correct. Again, if I'm acquiring a different company, then also what I need to check if is I'm audible? Yes. So what I need to check is when I'm tendering a resolution plan.
Hello?
Is this audible?
Yes, sir.
Yeah. So at the time of tendering a resolution plan, I in my own capacity is proposing a resolution plan. But while proposing a resolution plan, what I need to check is when we again go into the definition of that connected persons, there will be a further definition which talks about related party. Now, if a related party of mine, is disqualified or is ineligible under 29A, automatically that will attract or that will applicable to me. Now, it is a matter of fight how you demonstrate that it was not who you, or it was not you who was connected with the business, with the company which was being managed or which was being operated by your father, and that separate, and again partition date, the grounds of the partition date. So I feel that it is a matter of debate, but per se it will not make you eligible to propose a plan.
Sir, in my view, I think it has to be seen from the aspect that how the partition actually has taken place. If
That
the
is
partition has
the
taken place from
rationale
the
of the
court,
participation.
like suit for partition has been filed before the court or an arbitration award has been there through a judicial intervention, then it
Right.
can safely be said that it is separate. Otherwise, just a affidavit that would suffice the purpose. It will be very difficult to establish that whether it is actually a partition or just an eyewash.
Absolutely, sir. Sir, I'm exactly on the point which was initially raised by you. The Supreme Court, this is something which I'm talking about in the SR matter. While determining the eligibility of the resolution applicant ArcelorMittal India Private Limited and Numittal Limited to submit a plan for SR Steel India Limited, the Honorable Supreme Court in its judgment dated October 4, 18, settled several issues relating to CIRP under the IBC. The highlights of the judgment covering section 29A, Supreme Court judgment provide a clarity and directions on the role and duties of RP. I was talking about this judgment only. When examining each resolution plan under 30 subsection 2, which is very crucial, we know that it is the commercial wisdom of the COC, but as far as the judicial intervention is concerned, that intervention is extended to 30 subsection 2. It is while examining the plan under 30 subsection 2 to confirm the eligibility or ineligibility of the applicant as per 29A. Supreme Court judgment requires that RP to ensure 29A compliance. RP needs to ensure that plans submitted are complete in all respect before they are placed before COC, who may or may not approve it. The RP is required to give his or her prima facie opinion to COC confirming if any law including 29A has or has not been contravened. Supreme Court ruling also emphasized that it would be in the fitness of the things if RP appends a due diligence report with respect to each of the plan under consideration and to state briefly as to why a plan does not conform to the law. So basically, I'm straight away to the point, to the answer of your question, that it was the Supreme Court which has made the things very clear in this SR matter. It is the COC that will approve or disapprove a plan given the statutory parameter of section 30 relating to submission of the plan, where a resolution applicant is found to be ineligible at the time of submission of the plan under 29C. The resolution applicant shall be allowed by COC, period not exceeding 30 days to make the payment of overdue amount in accordance with 29AC. So this was question to your, and again, there is another answer to your question. I am on that part. It is imperative to identify who are the real individual or entity who are acting jointly or in concert and who have set up such a corporate vehicle for purpose of submission of the plan. For acting jointly, what is to be ascertained is whether certain persons have got together and are acting jointly in the sense of acting together. It includes any understanding, even if it is informal, even if it is to indirectly cooperate to exercise control over the CD. Whether person is or is not acting in concert depends upon the fact of each case. So this is straight away answer to your next question. Yes, there are few things to have a discussion with you, and that is pertaining to this is 29AC, and this is what I was talking about, that how come the intent is important. This is one of the case which was the NCLAT. It was challenged before the NCLAT. It is pertaining to NCLT Mumbai. Section 29AC of the Insolvency and Bankruptcy Code bars a person or promoter who has an NPA classified account of the CD under their control from taking part in the insolvency resolution of the corporate debtor. This is a case wherein the NCLT had to decide whether Section 29AC of the code disqualified individual who were not in charge of the company, but it became a non-performing asset, but were in charge when they submitted a plan. The decision would have far-reaching implication. Now let's see the case where an appeal was made by Navayuga Engineering challenging its disqualification from presenting a plan for a corporate debtor. Athena, a company set up for executing a hydroelectric project in Arunachal Pradesh. Have a look on into it. These are the facts. The bone of contention and the reasons for disqualification was Navayuga's close business ties with the corporate debtor. In 2013, it was Navayuga who invested a substantial amount through its wholly owned subsidiary, that is Regina Infrastructure, for 21.55% stake in the corporate debtor. Subsequently, in 2016, MOU was signed stipulating further investment by Navayuga for an equity share of 51% in corporate debtor. In 2013, the corporate debtor loan was declared as an NPA. October 2017, Navayuga transferred its entire shareholding in RIPL to two different individuals. Soon after, insolvency proceedings were initiated against the CD, a short-term lender, triggering CIRP in 17. Now, this Navayuga, who was having an indirect control through its wholly owned subsidiary, has submitted a plan for lender's consideration and approval. The COC informed Navayuga that it was not eligible to submit a plan under 29AC. Navayuga argued that the objective of 29AC was to disqualify only those individual or promoter who caused or were responsible for corporate debtors account being classified as an NPA. It said that the CD's account was classified as an NPA before execution of that MOU in 16. Further, Navayuga also argued that it did not have any control over the CD either before or after the signing of MOU. The rationale behind Navayuga's argument was that MOU in 2016 was merely a conditional contract, which never saw the light of the day. Navayuga also underscored the fact that it has transferred 100% stake in its wholly owned subsidiary prior to initiation of CIRP. When IBC was enacted, the concern was that individual who contributed to the default of the company could misuse the code to gain the control over the CD after forcing heavy haircuts. To prevent such individual from misusing the law, 29A was brought in. Enclet opined that giving the objective of 29AC, giving a restrictive interpretation to the provision would be incorrect. In this regard, the reliance was placed on the decision in ArcelorMittal India versus Satish Kumar Gupta to observe that 29A applied to not only those who led corporate debtor to slip into NPA, but also would apply to those who, despite being controlled, were either avoiding or not taking any active step to pull out the CD from financial misery and declassify the account of NPA. Enclet felt that MOU could not have read to mean the management and control of the CD was to be given to Navayuga only upon fulfillment of contingency. So Navayuga may have right to arguing that it was not promoter of the CD from the beginning. However, after execution of MOU in 16, Navayuga was given a control and the management of the CD. Thus, Navayuga was held to be ineligible. Enclet decision marks a significant development. So this is what I would like to say. We were discussing that if my account or the account of the persons who were in the management or in control of the corporate debtor, if the account is NPA, we were always or we are always going to be considered as a person who was having control over the corporate debtor's business at the time when the account was classified as an NPA. And the disqualification in this case is attracted to Navayuga, considering the fact that there was already an indirect control and it was more than 20% indirect control through its wholly owned subsidiary. And later on, there was an MOU which has extended his control of Navayuga in the corporate debtor up to an extent of 51%. And prior to the initiation of CIRP, the indirect control through its wholly owned subsidiary, what Navayuga has done is it has disinvested those investment in its wholly owned subsidiary in some other's name. But Enclad has taken a concrete view that in the year 16, even after the fulfillment of certain condition of MOU, Navyuga was having a control through its wholly owned subsidiary, and Navyuga has made no attempts to bring that corporate debtor out of NPA, despite being a control, where either avoiding or not taking any step to pull out the CD from the financial misery. That is something which is a leading reason. Now, just opposite case. Now, this is pertaining to 29AC. I'm again discussing one more case pertaining to 29AC. And this is what I already discussed, that just because of I'm the promoter, or just because of I was a director, or just because of I was having a control over the companies or the corporate debtor, that does not make me ineligible. I will be treated as ineligible only when that 29A subclause C makes me ineligible. That means if my account is NPA, if the account of the corporate debtor is NPA and I was the one who was having the control over the management, or I was the one who was the promoter of that corporate debtor. Now, here in this case, this is Vishram Nayan. This is one of the case wherein the Enclad RP has challenged the decision of the NCLT. The impugned order has rejected a plan that has been approved by the, so COC has approved the plan, and NCLT, the adjudicating authority, has rejected the plan on the grounds that the plan was submitted by the ex-director and successful resolution applicant of the corporate debtor, namely the Blue Frog Media Private Limited. Just have a look on that part. Here, Mr. Mahesh Mathi, ex-director of the successful resolution applicant, ex-director of the corporate debtor, has proposed a plan. The plan has got necessary approval from the COC, but the plan was rejected by the NCLT. The central issue pertaining to the interpretation of 29A of the IBC, specifically focusing on 29AC, which deals with the eligibility criteria of SRA. Vishram Narayan contended that the NCLT decision was erroneous. He emphasized that the absence of specific disqualification factor in 29A and questioned the relevance of SRA's formal role as a promoter, director in determining his eligibility. I said, this is what I said, that just because of I was holding the position of director or promoter or a shareholder, that does not per se make me disqualified. The appeal challenged the order dated 18th August 23 issued by NCLT Mumbai bench, which rejected the RP's application for approval of the plan submitted by SRA for CD. The plan had received the approval from COC with 92% voting shares. NCLT found that SRA, who had resigned on March 18, stood ineligible under 29A of the code to submit a plan. NCLT concluded that SRA's prior role would adversely impact the CIRP, leading to rejection of the resolution plan. The appellant argued the successful resolution applicant, the promoter of the CD, has argued that 29A of the code does not automatically disqualify all promoter and directors, and that disqualification must be linked to a specific clause within 29A of the code. The appellant asserted that SRA does not meet any disqualifying criteria under 29A. They specifically argued that 29AC of the code cited by NCLT was inapplicable, as none of the banks involved were creditor of the CD, rendering the clause irrelevant. And Enclad held that, has set aside the impugned order and revived the RP's application for fresh consideration by NCLT, noted that 29AC of the IBC only applies when applicant or associate has an account classified as an NPA with CD. NCLT considered that absence of any material to suggest that the account of SRA or the CD was NPA on the date of plan submission. No evidence was presented to establish any bank as a creditor of the CD. Only individual creditor was listed in Form H. Enclad emphasized that a person is ineligible to submit a plan only under a specific clause of A to G of 29A. So basically, and again, the reference was given here. It was determined that none of these clauses applied to SRA in the present matter and relied upon the Honorable Supreme Court decision in Haribabu Tota versus Sri Astraya Infracon Limited, highlighting that there is no per se disqualification under 29A for promoter. The decision to declare ex-director ineligible based solely on the past role without reference to specific clause of 29A is found to be erroneous. Consequently, the rejection of plan was deemed unsustainable, requiring reconsideration for the plan. So this is very clearly mentioned that the NCLAT decision highlights a nuanced interpretation of 29A with particular emphasis on the specific criteria for determining ineligibility, which clearly states that just past role as a director or the promoter will not inherently disqualify the individual from becoming a resolution applicant. Instead, eligibility is contingent upon satisfying the explicit criteria outlined in 29A of the code. So this is pertaining to 29AC, both this. In the former, where we have seen that how indirect control has also made me disqualified, and later on it has clarified by the NCLAT that just because of my position or just because of my role in the corporate debtor, I may not be presumed as ineligible under 29AC. In order to be treated or consider or debar me to submit a plan, it is important for the authority to identify me as disqualified because of ineligibility under 29A. If I'm not ineligible under 29A, just because my position on the corporate debtor cannot make me ineligible as far as submission of the resolution plan is concerned. One more thing, and this is pertaining to a Gujarat NRE Coke Limited. This is also one of the leading Supreme Court judgment with regards to 29A vis-a-vis 230 of the Companies Act. This is one of the landmark judgment as far as how the applicability of 29A will also extend to the liquidation regulations, or why section 230 does not permit the ineligible person under 29A to sponsor a scheme of compromise and arrangement, what we were discussing. So it was section 29A of the Insolvency and Bankruptcy Code lists the persons who are not eligible to be a resolution applicant. And you know that post liquidation, the attempts can be made to bring a corporate debtor back on its feet through the scheme of compromise and arrangement under section 230 of the Companies Act 2013, which deals with compromise or arrangement with the creditors and members. But I said, the purpose of bringing 29A, the rationale of bringing 29A will be lost if it will not extend to the section 230. Otherwise, what will happen? The one who is not eligible under 29A will be sponsoring the scheme of acquiring the corporate debtor under section 230. So the objective is to keep the corporate debtor away from those promoter, those director, those controller who ultimately resulted into that corporate debtor facing CIR. The Honorable Supreme Court in Arun Kumar Jagat Karma versus Jindal Steel and Power Limited. I said this is the Supreme Court in case of Arun Kumar Jagat Ramka versus Jindal Steel and Power Limited in relation to Gujarat NRE Coke Limited, in which the Supreme Court has linked section 29A and section 230 of the Companies Act. But again, contrary to this is 12A. Anyways, we will be dealing later on. 12A is all about a withdrawal of the application. And that is all about my settlement plan, which is being accepted by the COC with 90% voting shares. But as far as 230 is concerned, 230 is altogether a different, wherein the corporate debtor, so resolution plan is failed or no resolution plan is reached and company is dragged towards liquidation. But still the attempts are being made to have last revival chance through the means of section 230. But I said, even 230 does not makes you, or even 230 will not give you an opportunity if you are not eligible under 29A. Now let's say look on that part. Fact of the case, Gujarat NRE Coke Limited, that is GNCL, ran into financial crisis due to adverse market scenario in early 2009. After 15, debt realignment scheme was submitted by the company, Gujarat NRE, but the same was not approved by the lenders. In 17, Gujarat NRE filed an application under 10 of the code with NCLT Kolkata. It's Arun Kumar Jagatramka, promoter of Gujarat NRE Cook, submitted the plan, but because of IBC ordinance dated 23rd November 17, promoter became ineligible to submit a plan. That is Mr. Arun Kumar Jagatramka, who is the promoter of Gujarat NRE Coke Limited, turns disqualified or ineligible. New plan was submitted by Rare Asset Reconstruction Private Limited, which was not approved by COC. Meanwhile, application under section 230 of the code, that is of the Companies Act 2013, was filed by the promoter of the company, which was accepted by NCLT, and against the same, Jindal Steel and Power Limited filed an appeal with NCLT in capacity of operational creditor. So it was Jindal who contested the order passed by the NCLT accepting the proposal of the promoter. Jindal Steel and Power Limited moved an appeal in capacity of OC of Gujarat NRE Coke. NCLT reversed the order passed by NCLT wide order dated 24th October 19, stating that restriction under 29A of the IBC would flow into section 230. By default, once any corporate debtor under IBC, as mentioned about Gujarat NRE Coke, was already under section 10 of the IBC, filed by corporate debtor itself. Against the order, Arun Kumar Jagatramka, promoter and the applicant as a member under 230, filed an appeal with Supreme Court. Now, this is the call of the Supreme Court which we need to take. 29A of the IBC. Section 29A was introduced in IBC through ordinance. It was 2017. Pursuant to section 29AG, promoter of the corporate debtor in which a preferential transaction, undervalued transaction, extraordinate credit transaction, or fraudulent transaction has taken place, and in respect of which an order has been made by adjudicating authority, is ineligible to submit a plan. If order is pending, that's altogether a different case. But if the application is pending, this will not make you ineligible. But if the order is passed by the adjudicating authority pertaining to a promoter of the corporate debtor, which was involved in the preferential or fraudulent or undervalued or extraordinary transaction with respect to an order passed by adjudicating authority, I am ineligible under 29A. 29A also restrict the person who are in concert with the person mentioned therein from submission of the plan. And this is what I was talking about since long. In concert has not been defined under the Amendment Act. And that's why it is very clear rule of the court that it will borrow the meaning assigned to them under the other act identified under the code, including SEBI. Therefore, definition of PAC, person acting in concert, will have to be borrowed from SEBI substantial acquisition of shares and takeover regulation that define person acting in concert as a person who have the common objective or purpose of acquisition of shares, voting right, exercising control over the company pursuant to an agreement, understanding formal or informal, directly or indirectly, cooperate for acquisition of share voting in exercise of the control of the company. So this is what, again, the Supreme Court again relied upon its own decision in Swiss Ribbon. And it was held that the primary focus of the legislation is to ensure the revival and continuation of the CD by protecting the CD from its own management and from a corporate death by liquidation. Both the things are equally important. To protect the corporate debtor from a corporate death and to protect the corporate debtor from its own management. 29A was introduced in IBC through Amendment 17, which makes promoter ineligible to submit a plan because of ineligibility under 29A. The essence in the case of company, investors and management of the companies are different. Board promoter take influence the majority decision of the company. 29A was introduced with the consideration that it is not apt to give a CD again in the hands of same management who may be the reason for initiation of CIRP. And Supreme Court has given this ruling. legislative intent behind enactment of the strict regime in relation to insolvency and bankruptcy was to provide an instrument for timely resolution of the creditor grievance. Correct interpretation of the IBC would be one which facilitate the salutary object and clears the cobwebs of the previous legal regime, which was essentially a corporate debtor's paradise. Supreme Court has again emphasized upon the judgment of Chitra Sharma versus Union of India and ArcelorMittal India versus Satish Kumar that 29 has been introduced with a specific purpose, which is to protect the interest of the creditor and disallow the indirect entry of the management, which is the responsible for the default. Person who is the cause of problem cannot be a part of the process of solution. 2035F, which I was dealing with the liquidation part, which deals with the power of the liquidator to restrict the liquidation from selling the movable or immovable, including actionable claims, to the person who is not eligible under 29A to submit a plan. And vis-a-vis section 230. 230 deals with the compromise and arrangement. And when you see regulation 2B gives 90 days time frame post order of liquidation. Pursuant to section 230 subsection 1, a compromise and arrangement can be proposed by a company itself or member or creditor or liquidator. As per proviso to 2B1, if the person is ineligible to submit a plan, such person shall not be the party to compromise an arrangement. Otherwise, the purpose of bringing 29A will be defeated. And the promoter are smart enough to take de-entry through the means of this liquidation process, even if the resolution plan fails, or even because of their ineligibility, restrict them to propose a plan, if section 230 will make them permissible to propose a scheme of compromise and arrangement. Company can be saved from getting dissolved if compromise and arrangement is entered between a company and creditor. Primary objective of the code is not only to ensure protection of creditor, but to provide protection to all stakeholders, continuing the operation of the company in the interest of all stakeholders. Hence, IBC allowed 90 days, even if the liquidation order is passed. Compromise and arrangement under 230 of the Act is the last chance to save a company. But Supreme Court has made it very clear that when a company is under liquidation, the statutory intention of the code has to be upheld, and ineligibility of 29A should be considered for section 230 when it is sought to be invoked. This is by the reason of the fact that backdoor entry sought to be prohibited under 29A cannot be permitted through 230. Supreme Court considered the commercial morality and held that the scheme of compromise and arrangement under 391, which is now section 230 of the Companies Act 13, must be intended to facilitate revival of the company. It was held that for a company under liquidation, the main aim of the compromise shall be revival of the company, and this purpose would be hampered if the erstwhile management is handed over the affairs of the company. So basically, this is what it was clarified, that section 29A was brought in with a specific reason. I said the objective of 29A or the purpose of bringing 29A will be lost if the 29A ineligibility will not be made applicable during the course of proposal of the scheme under section 230. And that's why, while proposing a scheme of compromise and arrangement under section 230, the criteria of 29A shall be mutatis mutandis applicable, and it will not give any further chance to a promoter or the ex-promoter of the corporate debtor through the means of 230 to place a plan or to place a scheme for compromise with its creditor or compromise with its member. So this is one of the leading judgment wherein the Jindal has moved an appeal, and NCLAT has reversed the order of the NCLT, Kolkata bench, and thereafter the promoter has further moved an appeal before the Supreme Court, but it has made it very clear that the intent of 29A is required to be, or the purpose or the rationale of 29A need to be maintained even during the course when a corporate debtor is in liquidation, and proposal of 230, 232, that is a person is sponsoring a scheme of compromise and arrangement, but if that person is not eligible under 29A, that will not make him eligible as a sponsor of the scheme under 230, 232. So this is one of the ruling of the Supreme Court. And last to see with 29AH, and this is the ruling of Supreme Court in the case of Bank of Baroda versus MBL Infrastructure Limited. And it has made the things very clear that if I'm a guarantor, I've extended a guarantee on behalf of a corporate debtor in favor of his creditor, then it will not make any difference whether the creditor in whose favor the guarantee is extended, whether he made an application against the corporate debtor and that application was admitted, or some other creditor has moved an application before the NCLT and the CIRP was initiated. The factor to be taken care of is if the corporate debtor is in CIRP and if the guarantee is already invoked by the creditor in whose favor the guarantee was extended, and even after the invocation of the guarantee, the amount is unpaid, whether in full or in part, it will make me ineligible because of the provision of section 29A clause H. Here it is. Bank of Baroda versus MBL Infrastructure. Supreme Court interpreted 29A of the code. Court has clarified whether a guarantor whose guarantee is invoked by a creditor is ineligible to submit a plan under 29AH. It also considered whether the word such creditor in 29AH mean all the creditor and not only the one creditor who has initiated insolvency proceedings. So this is what I said, that word such creditor was making the provision ambiguous. The provision was, if I have extended a guarantee on behalf of a city in favor of its creditor, and if that guarantee was invoked, and even after the invocation of the guarantee, the amount is unpaid, whether in full or in part, and such creditor has moved an application before the adjudicating authority for initiation of CIRP and the application is admitted. So the confusion is whether it is looked into that whether the same creditor has initiated an application or any creditor. So such creditor is similarly placed creditor. Whosoever may be the creditor, if the creditor has initiated an application and if the application is admitted, and if the guarantee is already invoked, and even after the invocation of the guarantee's amount and unpaid, in full or in part, it will make me ineligible to act as a resolution applicant. The court ruled that the phrase such creditor in 29AH must be construed to mean similarly situated creditor once the insolvency application is accepted by the adjudicating authority. This is the case wherein Mr. Anjani Kumar Lakhotia founded MBL Infrastructure Limited, 90s. MBL Infrastructure Limited secured loan or credit facility from consortium of bank. MBL failed to repay the loan and some of the bank in the consortium were obliged to repay rely the personal guarantee provided by Mr. Lakhotia. In exchange of the credit facilities obtained by MBL, the RBL Bank filed an application with Kolkata bench of NCLT under 7 to initiate CIRP of MBL, and the application was admitted. Subsequently, the IBC Ordinance 17, that is 23rd November 17, was notified and 29A was added to the code. COC met to discuss the implication of the modification regarding Lakhotia's ability to submit a plan. Lakhotia's resolution plan was authorized by NCLT, and directive was also issued that the settlement plan would take effect immediately. The same was challenged before the NCLAT, and NCLAT upheld the NCLT decision and refused to intercede. The said order was assailed before the Supreme Court and Supreme Court. The court interpreted 29A of the code on the basis that object behind 29A was to balance the interest of COC and CD while preventing unwanted elements from advancing their personal interest. It was also designed to keep out of categories of the person who may not lend confidence to the resolution process by virtue of their disqualification. Court analyzed the scope of 29AH and stated that after a person issued a guarantee in favor of a creditor for credit facility obtained by CD, in event that the application for bankruptcy was allowed and the guarantee was invoked, bar on ineligibility would undoubtedly apply. The court noted that the requirement of the section is that guarantee in favor of the creditor must be executed, and once an application for insolvency is accepted by the creditor, the proceedings would be in rem and the creditor of the same class would have equal rights. Therefore, disqualification under 29AH would apply on invocation of guarantee by creditor, even when the application for insolvency resolution process is filed by other creditor. The ineligibility of person is with respect to participation of applicant in resolution process and not ineligibility with respect to one creditor against the other. The court considered that subsequent amendment in the law would make the resolution application ineligible, even though at the time of filing of application for insolvency, the resolution applicant was eligible. So it also make it very clear that if I have extended a guarantee on behalf of CD in favor of its creditor, now it will not make any difference whether the same creditor has moved an application against the CD to initiate CIRP, an application is admitted, or some similarly placed creditor has moved an application against the CD and the application is admitted. The important factor is if the application to initiate CIRP is admitted, and if the guarantee is invoked, and even after the invocation of the guarantee, if amount is unpaid, whether in full or in part, it will make me ineligible to act as a resolution applicant. So that is the clear ruling of the Supreme Court in this circumstances. I would like to give a pause in this discussion and would like to keep the platform open for the question and answer, or to have the views with regards to the provisions of the code which we discussed.
Sir,
Yes, sir.
at the time my internet got disconnected. We were, sir, here intent of IBC is not affected, sir. This person, I am quoting, he is an outsider, not at all related to present CD. He is coming just to acquire the company. Father borrowed and father was doing business. This fellow minor was minor. Later he became major and started his own business, and he acquired some funds from grandfather, and now he came for acquiring the company. And present company, present CD, he is not at all related to this company. This person, as an youngster, he want to be an entrepreneur by acquiring the company.
So what you mean to say is the company is not the same company wherein his father was engaged?
No, sir, no.
But his
sir.
father is one of the persons ineligible under 29A.
That was a previous company. That is a different business. Yes, sir. You are correct.
What time frame has been expired from the date when that company, which was under the control of the father, was gone into CIRP?
Maybe around 3 years, sir. 3 years.
3 years. Today, the son of that father, the son of that ineligible father or a disqualified father is intending to propose a resolution plan for some other company.
Some other company. Yes, sir.
Then just because of the status of his father, his eligibility under 29A is being questioned.
They came with separation, partition deed, duly executed.
Duly executed before?
More than 1 year before submitting the EOI.
Before submitting the EOI for this company?
Yes, sir.
But not before that company which went into CIRP, which was being controlled by his father.
No, sir. After long period, 3-4 years later.
That is what I'm telling.
Correct.
Meaning thereby, when that company, today it is my contention, my bone of contention is, I was not engaged in the business of my father.
Yes, sir. You are correct.
Or I was not a contributory to his situation.
Exactly. You are correct.
See, it is the judiciary how it is going to see, because prima facie I will be, or
Ah.
I am.
I checked proof transactions of old company also. Nowhere his father, the son name is there. Nowhere.
That's correct.
Contribute.
That is correct. That is correct.
No.
But now the point is, just because of this partition deed, will it bring an end to my relation with my father?
Naturally. Yes, sir.
No, no, sir.
No?
No, it will not. It will not. It will not.
I got your point. See, the intent is very fair as far as the new resolution applicant is concerned. This newcomer is concerned. This newcomer is having no roots with that.
Yes, sir. Yes, sir.
I got your point. But this is something which we need to. This is now not a question of law. Now, this is the question of fact.
Fact. Yes, sir. Similar cases could you face anywhere, sir?
I have not faced, sir.
Similar cases.
Because when it's a clear-cut relationship between a father and son, wherein a father is disqualified.
Yes, sir. Yes, sir.
A father is ineligible, and my son or the father's son is contending for some other resolution, or as a resolution applicant for some other corporate debtor. Correct, and because of his father's history, he is being treated as 29A disqualified or ineligible person. It is a matter.
Hello? Hello, sir? Hello?
I think the speaker got disconnected, right?
Yes, sir.
Yeah,
Yes,
I
sir.
think so.
The audio is not.
Audio, video also. Video
Sir,
also gone.
anybody from institute available?
Yes, sir. Institute, na? I think nobody. Any phone number we have to.
Sir, the speaker is reconnecting.
Speaker is the problem.
Sir, he is re-logging.
Okay.
Okay, technical issues. Speaker. Yes, sent a message.
Is it audible?
Yes, sir. Now audible, sir.
See, there was lost in connection. I was facing some technical issue, but yes, coming back to your point, I would like to say that It again goes with the RP, that how RP opined this before COC.
Yes, sir. Mine is the RP, sir. Myself is the RP. You tell
Correct,
me
sir.
what to do. How to
Correct,
convince.
sir. You need to simply place your opinion before the committee of creditor that how it will not impact if this resolution applicant is given an opportunity
Okay, sir.
to place its plan before the COC, and if this is subject to the ultimate approval of the COC and NCLT. So you need to place your due diligence report along with your opinion.
Yes, sir.
While proposing the plan before the committee of creditor, you need to demonstrate that how his linkages are not with his father's business,
Yes,
or how he is not responsible for the deeds of his father,
correct,
or
sir.
how his father's history will not impact the ultimate approval of this plan,
Correct,
or
sir.
the future of this corporate debtor if goes into the hands of this son.
Yes, sir. Yes, sir.
So
Yes, sir.
ultimately, it is up to you to decide that how you can demonstrate the ultimate intent of the court with regards to the present fact wherein the son, in spite of being a related party to a disqualified or ineligible resolution applicant,
Yes,
is
sir.
still considered to be eligible for the purpose of this corporate debtor.
Yes, sir. Yes, sir. And COC also approved pending approval in
Correct. So
NCLT.
this
Yes,
is
sir.
now again, this is the commercial wisdom which is in the hands of
Yes,
the
sir.
committee of creditor, and ultimately the judicial wisdom is in the hands of the adjudicating authority.
Yes, sir.
So
Judicially.
your role is to study the background,
Ha.
to demonstrate that how fairly this will impact the corporate debtor if the plan gets accepted.
It will not affect, sir. Negatively, it will affect positively only. He will run the business.
Because the primary aim of the code is to bring the corporate debtor back on its feet, whether it is own feet or somebody else's feet.
Yes, sir. Yes, sir. And nowhere old management is coming in this way.
Absolutely.
That's the resolution. Yes, sir.
I agree to that.
Yes, sir. Yes, sir. Okay,
But
sir.
coming back to your primary question that whether it is the responsibility of RP, yes, the
Yes, sir.
responsibility will be of the RP to demonstrate the fact before the committee of creditor about the eligibility or ineligibility under 29A,
Yes,
bringing
sir.
its roots from the SR case. Anything beyond this, sir?
Sir, please repeat your mobile numbers or put in the chat box, sir. Mobile number.
If there are certain more concerns with regards to 29A, because 29A is itself quite difficult to interpret, but it is practically very difficult when one sits for acting as a person or professional undertaking due diligence, because for that you need to have an exhaustive list of all the related parties, you need to have an exhaustive list of all the connected parties, and you need to have an exhaustive list of all the entities wherein the related parties or connected parties are having its business roots. So it depends upon the information available, and it depends upon the extensive search and the reliability over the credit rating agencies, CIBIL reports. And there are multiple factors, and I must say that still there are multiple things which are not so resolved.
Yes,
like
sir.
what we have seen, a person is disqualified to act as a director. Now here you will treat only those person who are disqualified to act as a director, against whom an order is passed by court or tribunal, or you will be having your independent judgment with regards to his eligibility or ineligibility by comparing or by having a look into the provision of compliance of 164. So I must say that there is certain things which are still not folded or unfolded, and it will be having, or this creases are going to be ironed out by the RPs by putting it before the adjudicating authorities, and the dissenting parties will bring it to the appellate court, and ultimately things may probably settled at the Supreme Court level.
Sir, just to extend to whatever you have said now, hypothetically, we have done the due diligence, but this nowhere we could find this, this 29A is not applicable. Can we just go for an affidavit and be done with it? Affidavit from the party saying that they are eligible.
Correct.
Can the RP be absorbed? I mean, can he get out of the issue by taking an affidavit? Suppose there's a problem.
Giving
at a
an
later date.
affidavit.
Yeah,
Giving an affidavit or undertaking is an obligation on the part of the applicant, but verification is a responsibility on the part of the RP.
RP. Okay.
Sir, the
Thank you,
same case, on the same matter, generally affidavit or undertaking we take in every case.
Yes, it is required, sir. Even if you are selling a property of the corporate debtor or any of its actionable claim, again, what we have seen in the liquidation regulation, because that debarrs a person ineligible under 29A to be a buyer of the corporate debtor's property. So this declaration or affidavit is something which you are taking for the sake of your comfort, but that does not stop you or that does not give you an immunity. If tomorrow the question is coming before you that in spite of being a declaration which was wrongly given or affirmed on an affidavit, but later on it was found to be incorrect, it is you who need to give a clarity, or it is you who need to give a submission. It's you who need to counter that how come the verification was undertaken by you or due diligence was undertaken by you and you found that affirmation as correct, or what are the background documents you are having to verify the correctness of the affidavit which is provided by the resolution applicant.
Sir, one more question. One CA. Previously, he was a professional director, but he was not a promoter. He was not having shares in that company. That company became NPA. And that later he resigned and he joined another company. That company is becoming a resolution applicant now.
Professional directors
Ah,
are basically
yes, sir.
professional directors are basically a non-executive directors.
Yes, sir. You are correct.
As far as the professional directors or a non-executive directors are concerned, there is no classification that which director to be treated as disqualified under 164.
Yes, sir.
So coming to a very factual background of section 164, section 164 is a disqualification which is applicable to all the directors of the company.
164 of Companies Act, na?
164 1 and 2 of the Companies Act, that applies to all.
164 1.
164 subsection 1 and subsection 2 of the Companies Act.
Okay.
There is no demarcation between the executives and the non-executives.
Okay. So 29A applies to this person?
Absolutely, yes, sir.
Okay.
Now you need to fight from the viewpoint of section 141 of the Negotiable Instrument Act that it's not the position, but it's the role which makes a difference.
Okay, okay.
So it's again your contention that how well you put your point that though you was holding the position, but there was no role which makes you ineligible under 29A because of that disqualification under 164.
Yes, sir. Yes, sir.
Because mainly in non-executive directors or such nominee directors are being appointed purposefully by an outside entity.
Outside
and they don't have any role to play on day-to-day operations.
Just to
and
come.
compliances, majority of the compliances goes into the responsibility of those key managerial personnel or the executive director who devote, you can say those who are in the whole time operations or affairs of the company. So there you need to demonstrate that how your role makes a difference and not your position.
Yes, sir. Yes, sir. Nice, sir. Thank you very much, sir.
Thank you very much, sir. It is a pleasure on my part also to be a part of this webinar wherein I have got an opportunity to have these interactions.
Yes, sir. Sir, very active. Nicely, Mr. Vinit.
Mr. Vinit, your presentation was just excellent, very lucid.
Lucid and point.
You've been able to link this 29A with the other sections and regulations as well.
Thank you very much.
Thanks a lot, sir. Thanks a lot.
Thank you very much, sir. Thank you.
Exactly to the point, sir.
Informative, sir. No words to express our gratitude.
Yes, sir.
Sir. Continuous,
much.
sir. Continuous
Thank you
for
very much.
2.5 hours. It's
Continuously.
Thanks a lot, sir. Thank you very much.
Nice.
you, sir.
Nice presentation.
Sir, for a nice
It
session.
was like bursting crackers during Diwali, you know. It was just.
Presentation also.
Sir, you prepared some notes, na? You share, sir?
We'll be sharing the same, sir.
Yes, sir. Yes, sir. And even if you can share that even code regulations marked, that will help, sir.
I will be
Please.
sharing.
Yes, sir. Please share, sir.
Thank you very much.
Thank you very much, sir, for such a nice and wonderful presentation. Please kindly share your presentation with us.
Thank you very much.
Madam, at what time we rejoin?
Also, now there is lunch time. We will be having second session at 2 p.m.
2 p.m. na? Okay.
Yes, sir, at 2.
2 p.m. We'll join at 2 p.m. Okay.
Okay, madam. Okay, right.
Ma'am, shall we start?
Yes, ma'am.
Good afternoon, everyone. Good afternoon, ma'am. Now the session will be taken by Shubham Agrawal, ma'am. Let me briefly introduce ma'am. Ma'am is a practicing company secretary and insolvency professional. She has done LLB, LLM, MCOM, and BCom. She is founder of AS Goyal and Company since 2012. Company secretary firm. She is engaged in providing assistance and support services to IP in CIRP and liquidation assignments. Apart from handling CIRP and liquidation matters, she is providing valuation in securities and financial assets, transaction audit, forensic audit, preparation and analysis of financial statements, drafting and implementation of resolution plan. She has experience in incorporation of companies and LLP partnership firms, due diligence, corporate governance audit, advisory in matters of merger and amalgamation, revival, restoration of company, annual filings, citing of companies, yearly and half-yearly compliances, and certification for listed and unlisted companies, etc. Now I request ma'am to start the session.
Good afternoon, everyone. I hope the PPT is visible to all of you.
Yes, yes, ma'am. Yes.
Yes,
Shall
ma'am.
we start?
Yes, ma'am.
So our today's topic is resolution plan, mandatory contents of the resolution plan, submission of resolution plan, waiting of resolution plan, and approval of resolution plan as per the Insolvency and Bankruptcy Code 2016. So before we start this topic, we will quickly take a tour of important sections and regulations mentioned under the IB code. What is insolvency? Insolvency is the inability of a person or corporation to pay their debts as and when they become due and payable. Bankruptcy is when a person is declared incapable paying their dues and payable bills. Liquidation is the process of the winding up of a corporation or incorporated entity. What is the objective of IBC? To keep alive to the company as much as possible, to promote the entrepreneurship and encourage the entrepreneurship, ensure a timely and effective resolution of insolvency and bankruptcy cases, balance the interest of all the stakeholders, including creditors, debtors, employees, to maximize the value of the assets of the corporate debtor, and to save the business as a going concern through restructuring, change in ownership, merger, and other methods. So we will quickly go through the important sections and regulations which is related to the resolution plan and IB code. Applicability. This code is applicable when the amount of default is minimum 1 crore. Section 6. The person who may initiate the CIRP, financial creditor, operational creditor, or corporate debtor. Section 7. Initiation of the CIRP by financial creditor. A financial creditor either by itself or jointly with other financial creditor or any other person on behalf of the financial creditor, as may be notified by the central government, may file the application for initiating CIRP against corporate debtor before the adjudicating authority. Section 8, demand notice. Section 9, application of initiation of the CIRP by the operational creditor. Section 10, initiation of the CIRP by corporate applicant himself. Section 14, about moratorium on the insolvency commencement date. The adjudicating authority by order declare in order itself the moratorium period, which will be during the moratorium period, there are the following prohibitions like institution of suits or continuation of pending suits or proceedings against the corporate debtor, including execution of any judgment, decree, or order in any court of law, tribunal, arbitration, or any other authority, and transferring, encumbering, alienating, or disposing of by the corporate debtor any of its assets or any legal right or any beneficial right therein. Any action to foreclose, recover, and enforce any security interest created by corporate debtor in respect of its property, including any action under surfacing, or the recovery of property by the owner lessor where such property is occupied by or in possession of corporate debtor. So these activities are prohibited during this period. So I have mentioned very highlights of the regulations. Regulation 6, public announcement within 3 days in Form A. Regulation 7, claims by operational creditor with proof. Regulation 8, claims by financial creditors with proof of claims. Regulation 9, workmen, claims by the workmen and employees. Regulation 10, substantiation of the claims. IRP or RP may call further information, evidence for substantiation of the claims. Regulation 12, submission of proof of claim. So any claimant who is submitting the claim form along with documents have to submit the proof of claim on or before the last date mentioned in public announcement. Regulation 12.2, if creditor fails to submit the claim within the prescribed period, then he may submit the claim on or before the 90th day. Now, in the recent amendment, he can submit the claim up to the issue of RFRP document. Regulation 13, verification of claim. Within 7 days of receipt of claim, IRP or RP shall verify the claim and make all the further information for substantiation of the claims. Regulation 16, committee with OC only, where no financial debt or all FCs are related party of corporate debtor, then committee shall consist 18 largest operational creditor, 1 representative elected by workmen, 1 representative elected by all employees, and voting will be in the proportion of debt, and same rights and powers as COC of FC. Regulation 17, constitution of committee of creditors. Committee of financial creditor will be formed. Related party will not be included in COC, and then IRP or IRP will file the report of constitution of COC to the adjudicating authority as per Regulation 17. Regulation 18, meeting of the committee. IRP will convene the first meeting of the COC within the T+30 days and may convene if the request is received from at least 33% voting rights consisting creditors. Regulation 25, voting by committee. the agenda items which require the requisite approval of the committee, then IRP shall facilitate the committee of the creditors to cast the vote upon the agenda item mentioned in the notice. And vote can be made by the raise of hands, by voice, by e-voting. Voting sheet will be prepared and voting window will be open for at least 24 hours. Regulation 27, appointment of professional. IRP or RP has a power to appoint the two registered valuer to determine the fair value and liquidation value of the corporate debtor. He can be any type of the professional like accountant, valuers, transaction auditors, consultant, GST consultant, TDS consultant, vetting professional, any professional who is required to discharge the duties on the, and he will be appointed on arm's length basis. Regulation 30, assistance of local district administration. IRP or RP may make the application to adjudicating authority for seeking assistance of local district administration in the discharge of his duties. Regulation 38, withdrawal of application. RP may, if settlement is done or the matter is going to be settled, then RP may make the application to adjudicating authority. However, it requires the approval of 90% approval of COC having consisting voting shares. Regulation 31A, regulatory fee calculated at the rate of 0.25% of realizable value to the creditors proposed under the resolution plan, which shall be payable to the IBBI, where such realizable value is more than the liquidation value, then where it is a condition, then it will be applicable. And regulation 33 and 34, it is related to CIRP cost, and COC shall fix and approve the expenses incurred by the IRP or RP or to be incurred or to be incurred. The expenses shall be the part of the CIRP cost, and cost shall be disclosed to the IBBI under regulation 34A and 34B. 34B, fees to be paid to the IRP and the RP, fees of the IRP or RP decided by the COC, and 34B for performance linked incentive scheme, where the resolution plan is submitted to the adjudicating authority within this time period, a table is mentioned, then COC may decide the performance linked scheme fee may be given to the RP. Regulation 35, fair value and liquidation value. Registered valuer shall submit to the RP after the physical verification of the inventory and fixed assets of the corporate debtor. If the two estimates are significantly different, then the RP will appoint third valuer. Significant difference means 25% difference of liquidation value. Regulation 35A, preferential transactions. When the RP determines that any preferential transaction has taken place up to 150th day, then RP shall apply to the adjudicating authority. Regulation 36, information memorandum. RP shall submit, first he will prepare, then submit the information memorandum in electronic form to each member of the committee on or before 95th day of the 90th day, it is now, having significant information about the corporate debtor, including operations, financial statements to the PR. So what are the matters which require the approval of COC of consisting 66%? Section 12, extension of timeline. Section 22, 27, replacement of IRP. Section 28, certain actions required approval of COC. Section 30, subsection 4, approval of resolution plan or liquidation. And section 21(8), subsection 8, all decisions of COC, other than these, it requires 51%. And in case of withdrawal of application, it requires 90% approvals. Now we will start the discussion about the topic resolution plan. The definition of resolution plan is mentioned in section 5, subsection 26. Resolution plan means a plan proposed by resolution applicant for the insolvency resolution of the corporate debtor as a going concern in accordance with part 2. And it may be, the plan may include the provisions for restructuring of corporate debtor, the plan may include the restructuring, a merger, amalgamation, merger, demerger, etc. And then the mandatory provisions of the code and regulations related to resolution plan section. We are going to discuss these sections and regulations which is related to our topic. First of all, section 25, duties of RP in relation to resolution plan. First, section 25, invite the PRA who fulfill such criteria as may be laid down by him, with the approval of committee of creditors having regard to the complexity and scale of the operations of the business of corporate debtor and such other conditions as may be specified by the board, to submit a resolution plan or plans and present all the resolution plans at the meeting of committee of creditors. So as per section 25, RP has a duty to invite the PRA who fulfill such criteria, which is approved by COC. So first the eligibility criteria, which is required as per the financial position of corporate debtor, RP will decide in consultation with COC. So eligibility criteria will be approved by the COC. Section 29, preparation of information memorandum. The RP shall prepare the information memorandum in such form and manner containing such relevant information as may be specified by the board for formulating a resolution plan. Means this information memorandum should consist all the information which will help the PRA to formulate the resolution plan. And relevant information means the information required by the resolution applicant to make the resolution plan for corporate debtor, which shall include the financial position of the corporate debtor, all the information related to the disputes, if any, pending by or against the corporate debtor, or any other matter pertaining to the corporate debtor as may be specified. So before submitting a resolution plan, PRA should not be eligible. He should be eligible under section 29. He should not be ineligible to submit the resolution plan under section 29A. Section 30, submission of resolution plan. The resolution applicant may submit the resolution plan along with affidavit stating that he is eligible under section 29A. So he has to give the affidavit that he is eligible under section 29A to the RP. This affidavit will be deposited. This affidavit will be submitted to RP prepared on the basis of information memorandum. The RP shall examine each resolution plan received by him to confirm that each resolution plan provides for. So RP will check that there is a provision for the IRP cost 30 subsection 2 subsection A. 30 subsection 2 subsection B provides for the payment of debt of operational creditor in such manner as may be specified by the board, which shall not be less. The payment to the debt to the OC should not be less than the amount to be paid to such creditors in the event of the liquidation of the corporate debtor under section 53, which is mentioned in. The amount would have been paid to such creditors if the amount to be distributed under the resolution plan had been distributed in accordance with the order of the priority in subsection 1 of section 53, whichever is higher, and provides for the payment of the debt to the financial creditor who do not vote in favor of the resolution plan. So it should have the provision for the payment of debt to the financial creditor who do not vote in the favor of, and which shall not be less than the amount paid to such creditors in accordance with which is defined in section 53(1) in the event of liquidation. Section 30 subsection 2 provides provides for the management, means when the PRA is submitting the resolution plan, these are the contents which should be incorporated while formulating the resolution plan, like IRP provisions for the IRP cost, provisions for the payment of the operational creditors, provides for the management of the affairs of the corporate debtor after the approval of the resolution plan, implementation and supervision of the resolution plan, and there should be a statement that the PRA is not contravening any of the provisions of the law for the time being in the force, means which is applicable right now on the corporate debtor. And it confirms, and he will mention that my resolution plan confirms the other requirements which may be specified by the board. The RP shall present, then after receiving the resolution plan, the RP shall present to the COC for its approval such resolution plan which confirm the conditions which is mentioned under subsection 2. If it complied plan, if it is present to the COC for its approval, then first he will make the due diligence. If it is IBC compliant plan, then he will put up for approval. The committee of creditor may approve a plan by the vote of not less than 66% of the voting shares of the financial creditors after considering its feasibility and viability. So when the COC will approve, COC will consider first feasibility and viability. Manner of distribution proposed. So manner of distribution can be as per a voting share, can be as per the priority and value of security interest of the secured creditor. Means if they are secured creditor, then they can consider the security interest value, or they can consider the voting ratio and etc., which may be decided by COC jointly by the 66%. Provided that the COC shall not approve a resolution plan submitted before the commencement of when the resolution applicant is ineligible under section 29A. The resolution applicant may attend the meeting of the COC in which the resolution plan of the applicant is considered. So RP can invite the PRA for the discussion and negotiation. Provided that the resolution applicant shall not have to vote, shall not have a right to vote. If he attending the meeting, then it does not mean that he will get the right to vote. unless such resolution applicant is also a financial creditor. The resolution professional shall submit the resolution plan as approved by the COC to the adjudicating authority after it's getting approved by the COC by 66% voting share. Section 31. Approval of resolution plan. So when if the now in section 30 it is approved from COC, it is in section 31 it will get approved by the adjudicating authority. So if the adjudicating authority is satisfied that the resolution plan is approved by the COC and also which meets the requirements of section 30 subsection 4, then it shall approve the resolution plan. After approval, it shall be binding on the corporate debtor and its employees, members, creditors, including central government, state government, or any local authority to whom a debt in respect of the payment of the dues arising under any law for the time being in the force, and such as authorities to whom the statutory dues are owed, guarantors, other stakeholders involved in the resolution plan. So it will be binding all that authorities, including any member associated with corporate debtor and involved in the resolution plan. Then, provided that adjudicating authority shall, before passing an order of the approval of the resolution plan, satisfy the resolution plan as a provision for its effective implementation. So, adjudicating authority will approve if it is having the provisions for effective implementation. Next, section 31 subsection 2 specifies that where the adjudicating authority is satisfied that it does not conform to the requirements referred in the subsection 1, it may by order reject the resolution plan. After the order of approval, the moratorium will be ceased. The moratorium order passed by the adjudicating authority will be ceased, and the RP shall forward all the reports relating to the conduct of the CIRP and resolution plan to the board and recorded on its database. Resolution applicant shall, pursuant to the resolution plan approved, obtain the necessary approvals. Now it is a duty of PRA to obtain the approvals, necessary approvals, which is required under any law for the time being in the force within a period of 1 year. So necessary approvals he may require for starting the operations of the corporate debtor. So he will take within the 1 year from the date of approval of resolution plan by the adjudicating authority. So section 30 and 31 was all about submission of resolution plan, approval of resolution plan by COC, and approval of resolution plan by adjudicating authority. So this section 32A prescribes that when the resolution plan is approved once by the adjudicating authority, and if any liability is occurred, or if there is any liability before the period of the CIRP, then how it will impact after the approval of resolution plan. Section 32A. So notwithstanding anything to the contrary contained in this code or any other law for the time being in the force, the liability of the corporate debtor for the offense which is committed prior to the CIRP shall be seized. So any offense which is committed prior to the CIRP shall be seized, and the corporate debtor shall not be prosecuted for such offense from the date when the resolution plan get approved by the adjudicating authority. And if the resolution plan results in the change in the management, obviously, if any third party acquire the company, then it will obviously change the management and control of the corporate debtor to a person who was not prior, means who was not earlier he was not the promoter or part of the management or control or related party of such person, or a person with regard to whom the relevant investigation authority has, on the basis of the material in its possession, reason to believe that he had abetted or conspired for the commission of the offense and had submitted or filed a report or a complaint to the relevant authority or the court. So if the resolution plan results in change in the management or control to a person who was not a promoter or in the management or in the control of the corporate debtor, a person with whom the relevant investigation has, on the basis of material reason to believe that he had abetted or conspired for the commission of the offense and submitted a filed report, complaint to the relevant authority. Provided that if the prosecution has been instituted during the CIRP against such corporate debtor, it shall stand discharged from the date of the approval of the resolution plan. So during the CIRP, also he will be discharged. And important provision is that no action can be taken against the property of corporate debtor in relation to the offense. Means if a corporate debtor is having any property and any offense which is committed to the prior to the commencement of the CIRP, when such property is covered under the resolution plan and that property is acquired by the PRA under the resolution plan and plan is approved by the adjudicating authority and a plan is get approved and which the results in the change in the control means someone else acquired the corporate debtor which result change in the control or sale of liquidation estate. In any case, who was not the promoter or in the management or control of the corporate debtor or related party of such person, a person with whom to relevant investigation authority has on the basis of its material in its possession reason to believe that he had abetted or conspired for the commission of the offence and has submitted or filed a report or a complaint to the relevant statutory authority or court. No action shall be taken. For the purpose of this, it is clarified that any action against the property of corporate debtor in relation to an offence shall include means this subsection 2 mentioned that no action can be taken. So which type of action cannot be taken? So it is clarified in this explanations which action like attachment, seizure, retention or confiscation. So these type of actions cannot be taken by any authority when the plan is approved and offence is committed prior to the commencement of the CIRP. Regulation 35, fair value and liquidation value. Fair value and liquidation value will be determined in the following manner. After the receipt of the resolution plan in accordance with the code and these regulations, the resolution professional shall provide the fair value and the liquidation value and the valuation reports to every member of the COC in the electronic form. So it is the duty of the RP to provide these information to the RP on receiving an undertaking from the member to the effect that. So RP has a duty to obtain an undertaking from the COC members. And such members will mention that he will maintain the confidentiality of the fair value and liquidation value and valuation reports and will not use the information contained or to cause undue gain, undue loss to itself or any other person and comply the requirements of section 29(2). Regulation 36A deals with invitation for the expression of interest. So how the resolution professional invite the resolution plan. So this is the first step. He has to invite in the form G to all the to invite the expression of interest from the PRAs. So the RP shall issue the invitation including evaluation metrics to the prospective resolution applicant in accordance with the 25(2)(h) to submit the resolution plan at least 30 days before the last date of the submission of the resolution plan. Where the invitation does not contain the evaluation metrics, the RP shall issue with the approval of the committee at least 15 days before the last date of the submission of the resolution plan. The resolution professional may modify the invitation, the evaluation metrics, or both with the approval of COC within the timelines given under the. So RP has must adhere to the timelines. So this is a format of Form G, and RP will issue this Form G for the invitation of the expression of the interest. Regulation 36A, the RP shall publish the brief particulars of the invitation in the Form G of the schedule, which is mentioned this on the website of the corporate debtor, on the website, if any, of the designated by the board for this purpose, and the RP shall publish the brief particulars of the invitation of the expression of interest in the Form G at the earliest, not later than 60th day from the insolvency commencement date from the interested and eligible prospective resolution applicant to submit the resolution plans. Regulation 36A, invitation for the expression of interest. In the one English and one regional newspaper at the location of the registered office and principal office, if any, of the corporate debtor or any other location where, in the opinion of the RP, the corporate debtor conduct the material business operation. So it may be published, it should be published in one English and one regional, and with wide circulation at the principal office, registered office, or where he seems that there it is the place of material business operations, and it will be published on the website of the corporate debtor, if any, on the website of the board, if any, and in the manner as may be decided by the COC. And the Form G shall state that where the detail in the Form G will mention RP will mention the address or state that where the PRA can download the detailed expression of interest. So generally, when the PRA requests to RP, then RP share the detailed invitation for the expression of interest, and Form G should provide the last date for the submission of the expression of interest, which shall not be less than the 15 days from the date of issue. And then detailed invitation, which will be prepared in the form of process memorandum, and which will specify the criteria for the PRA. Means the PRA who fulfill the criteria which is mentioned in the detailed invitation will be entertained for the final list. So the detailed invitation, which will be prepared in the form of process memorandum, so it should contain the criteria for the PRAs, which will be approved by the COC after consultation with RP, and state the ineligibility norms under section 29A, and provide such basic information about the corporate debtor as may be required by the PRA for expression of interest. So it does not require any payment of any fee or non-refundable deposits for the submission of expression of interest. It is PRA not necessary to submit any deposits or like to do any payment of fee. Any modification in the invitation for the expression of interest may be made in the manner as initial invitation for the expression of interest was made, provided that modification shall not be more than once. A PRA who meets the requirement of the invitation for the expression of interest may submit within the timeline given in the Form G. The EOI received after the timeline will be rejected. The EOI should be unconditional and shall be accompanied by these undertakings and these conditions, which is mentioned in 36A7. The expression of interest should be unconditional and should be accompanied by an undertaking by the PRA that it meets the criteria specified by the committee. So I will share the one sample process memorandum, which should contain these all these provisions mentioned in the regulation 36A, like an undertaking by the PRA that it meets the criteria specified by the committee. So I just show you the So after we will complete this provision, I will show you the information and format of undertakings, relevant records in the evidence, undertaking by the PRA that it does not suffer from any ineligibility under section 29A, relevant information and records to enable an assessment of the ineligibility, and undertaking by the PRA that it shall intimate the resolution professional forthwith if whenever he will become ineligible to participate in the CIRP process. And undertaking by the PRA that every information and records provided in the expression of interest is the true and correct, and discovery of any false information or record at any time will render the applicant ineligible to submit the resolution plan and forfeit any refundable deposit and attract any penal actions under the code. And undertaking by the PRA to the effect that it shall maintain the confidentiality of the information and shall not use the information to cause any undue gain or undue loss to itself or any other person, and comply with the requirements as given under section 49(2). So these are the mandatory provisions which should be mentioned in the detailed DOI as per regulation 36A, like undertaking from PRA and relevant records in the evidences of the meeting criteria. Like if the PRA is submitting his expression of interest, then he has to attach the relevant records that he is fulfilling the criteria, like net worth certificate. He has to give us a brief profile about the PRA and the necessary undertakings which is required as per regulation 36A7, that he is eligible under section 29A. He has to give the undertaking on the stamp paper, relevant information, and the undertaking by the PRA that he will inform me when he will become ineligible in future during CIRP. And undertaking by the PRA that every information and records is the true and correct to the best of his knowledge. And undertaking by the PRA that he will maintain the confidentiality of the information and shall not use the information to cause any undue gain or undue loss to itself or any other person. Then 36(8) deals with that RP should conduct the due diligence based on the material on record in order to satisfy the PRA complies with. So it is a duty of the RP that he would make the due diligence of the resolution plan as per that if he will determine that he is eligible under section 25(2)(h), he is eligible under section 29A and other requirements which may be required for the invitation of expression of interest and the terms which is approved by COC in the detailed DOI. The resolution professional may seek any clarification, additional information, or documents from the PRA for conducting the due diligence. The resolution professional shall issue a provisional list of the prospective resolution applicants within the 10 days for the submission of the expression of interest to the committee and all the PRA. Then after RP will make the due diligence of the plan, and if he satisfied that this PRA conforming to the requirements of section 25(2), which he is confirming the eligibility criteria which is mentioned in the detailed DOI, and so he will check this and thereafter he will prepare the provisional list of the PRAs within the 10 days, and he will share the provisional list with the COC members and with the PRAs, all PRAs who have submitted the expression of interest. And then 5 days time is given to the PRAs to make any objection for the inclusion or exclusion of their name in the list. And then regulation 36(8)(12) says that after giving the 5 days time for raising objections, if there is no objection is received or objection is received, then he will prepare, RP will prepare the final list of the PRA within the 10 days of the last date of the receipt and will share to the committee of the creditors. The final list will be shared to the COC. Regulation 36B, request for the resolution plan. So 36A is all about invitation of the expression of interest and the due diligence by the RP of the expression of interest received from PRAs. Regulation 36A10, we have discussed it, and then regulation 36B, request for resolution plan, RFRP. Any modification in the request for resolution plan or the evaluation metrics issued under the sub-regulation shall be deemed to be a fresh issue. So it will be, if RP want any modification, then it will be approved by the COC and it will not be more than once. The resolution plan may, with the approval of the committee, extend the timeline for the submission of the resolution plan. So if there is any situation like PRA is unable to submit the resolution plan within the timeline mentioned, then RP will take the approval of the COC and will extend the timeline for the submission of resolution plan and will inform to the PRA. If resolution professional does not receive the resolution plan in the response to the request under this regulation, then he may, with the approval of the committee, issue the RFRP for the sale of the one or more of the assets of the corporate debtor. So he can do so as per section 6, as per regulation 6A, sub-regulation. The RP may, with the approval of a committee, reissue the RFRP if the resolution plan received in response to an earlier request are not satisfactory, and subject to the condition that request is made to all PRAs in the final list. So request is made to all the PRAs. Regulation 37 deals with the resolution plan. So what are the measures which may be provided in the resolution plan? So this deals with the measures which PRA may provide in his resolution plan. The resolution plan shall provide for the measures as may be necessary for the insolvency resolution of the corporate debtor for maximization of the value of his asset, but not limited to the following. So these are the measures which may be incorporated by the PRA in the resolution plan. So how he will revive the corporate debtor? Transfer of all or part of the assets of the corporate debtor to one or more person. He may mention any of these measures in the resolution plan. Sale of all or part of the assets. Restructuring of corporate debtor by the way of merger or amalgamation or demerger. So he may propose in the resolution plan that he will structure the corporate debtor by the way of merging this company into this company, amalgamation of this company. Substantial acquisition of the shares of the corporate debtor or the merger or consolidation of the corporate debtor, cancellation or delisting of any shares of corporate debtor, satisfaction or modification of any security interest, curing or waiving of any breach of terms of any debt due from corporate debtor, reduction in the amount payable to the creditor, extension of a maturity date or change in the interest rates, whatever, as the PRA thinks fit. Amendment of constitutional documents, issue of securities of the corporate debtor for cash or for other than cash, change in the portfolio of the goods or services produced, change in the technology used which is currently in use by the corporate debtor, obtaining the necessary approvals from the central government or state governments, sale of the one or more assets of the corporate debtor to one or more successful resolution applicants. So these are the measures for the resolution of the corporate debtor for the value maximization of its assets. It may be mentioned in the resolution plan as per regulation 37. Regulation 38, mandatory contents of the resolution plan. So when the PRA submit the resolution plan, it should contain all the mandatory contents of the resolution plan, which is mentioned in the regulation 38. In the absence of the mandatory contents of the resolution plan, the plan will not become the IBC compliant plan. So what are the mandatory contents of the resolution plan? It should be incorporated. Regulation 38(1)A says that the amount payable under the resolution plan to the OC shall be subject to the priority over the financial creditors. First condition, Regulation 38(1)A. Regulation 38(1)B. The amount payable under the resolution plan to the financial creditor who have a right to vote and did not vote shall be paid in the priority over the financial creditor who voted in favor of the resolution plan. Means who have a right to vote but who did not vote in favor will get priority. Regulation 38, a resolution plan shall include a statement. Means this statement should be incorporated in the resolution plan that it deals with interest of all the stakeholders, including financial creditors and operational creditors of the corporate actor. A resolution plan shall include a statement giving the details if the resolution applicant or any of its related parties fails to implement or contribute to the failure of implementation of any other resolution plan approved by the adjudicating authority at any time in the past. A resolution plan shall provide the term of its implementation, means what is the time period given by the PRA for the payment of the debt. What will be its implementation schedule, means it will be 6 months, 3 months, 12 months, 1 year, 2 year, whatever the term may be offered by the PRA. So it should be mentioned in the resolution plan. The management and control of the business of the corporator during its term, means when the PRA is submitting the resolution plan, then he should mention that who will manage the affairs and control of the business of the corporator during its term, and the detailed analysis, the detailed overview of the management and the detailed profile of the management of the control of business should be mentioned in the resolution plan, and adequate means for supervising its implementation. So when the PRA is submitting the resolution plan, he will provide the directors, members, or who will supervise its implementation of the plan. Regulation 28, mandatory contents of the resolution plan. So regulation 28, we are running in this regulation which is providing the mandatory content, so it should be incorporated and formulated in the resolution plan. Provides for the manner in which the proceedings in the respect of the avoidance transactions, if any, under the chapter 3rd or fraudulent or wrongful trading will be pursued. So resolution plan should contain this provision, like if there is any application which is pending under section 43, 45, 66. So how it will be pursued after the approval of resolution plan. So treatment of this treatment of this provision should be mentioned in the resolution plan, that after the approval of the resolution plan, who will pursue this application. And the resolution plan shall also demonstrate these important factors. 38(3). A resolution plan shall demonstrate that it addresses the cause of default. So first of all, it addresses the cause of default. So like a corporate debtor has did the default, that there is a huge default, then resolution applicant PRA should mention that how he will address this default, and he will demonstrate that it is feasible and viable, and it should be feasible and viable in the as per the COC also, because COC will approve the resolution plan after considering the feasibility and viability, whether it will address the cause of default or not. So it should have the provision for its effective implementation. So effective implementation means when the resolution plan is approved, then various legal procedure has to be followed for the implementation of the resolution plan, like for the change of board of directors, issue of NOC, handover of the documents. So there are few steps which is required to be complied for its effective implementation. So PRA should incorporate these provisions in the resolution plan. So it has the provision for the approvals required and the timelines for the same. So if the corporate debtor is running the business which require the approval, then PRA should also formulate that these approvals he will require to commence the operations of the corporate debtor. The resolution applicant has the capability to implement the resolution plan. So PRA will demonstrate that he is having these capabilities like financial capability, technical capability. He is having this manpower and all. So he will demonstrate the capability to implement the resolution plan while formulating the resolution plan, which is to be submitted to RP for corporate debtor. The committee may consider the requirement of a monitoring committee for the. So generally there is a provision of constitution of the monitoring committee. Monitoring committee will implement and supervise the implementation of the resolution plan for the benefit of PRA. Regulation 5 says that where the committee considering if the COC seems that there is a requirement of the monitoring committee who will supervise the implementation. So if it is necessary and if COC recommend, then it will have decide to constitute the same with the same RP or with another IP or any other person as its member. So monitoring committee will form the part of same RP or another IP, and it will consist of one representative from the PRA and one representative from the financial creditors. Provided that where the RP is proposed to be a part of the monitoring committee, then monthly fees payable to him, which shall not exceed the monthly fees received by him during the CIR.
Ma'am, I have a question.
Yes.
This
Yes.
monthly fees, this circular has come in the month of February, I think, regulation. So if any resolution is passed in the year to 2020 or 2021, where the monthly fees is more than the RP fees, then what will happen? And the plan is filed with A. And
you are telling about the monthly fees of RP during monitoring committee?
Yeah, monitoring committee, RP professional, yes, monitoring professional.
So there is which date circular you are talking about for the monitoring?
When this circular is 16 February, this does not exceed the monthly fees of the RP.
So when it is applicable, then when the circular is applicable, then from thereafter this provision will be applicable, and
But
thereafter
the recent plan is already being passed by COC in 2020.
2020, then it will be carry on. Then it will be then it is not the contravention of any provisions because it is already approved by the COC from back date.
Back date, yes. Okay, thank you.
So any other discussion members want to do before proceeding further? So then the session will be more interactive. When the session will be more interactive, then we will enjoy. Any topic members want to discuss or deliberate? Because the topic which is related to the resolution plan is not so much vast, we can consume 3 hours. So it is better to discuss the topics or anything, any question or anything which is related to this topic or any other topic in which members are interested. Okay. Now, Regulation 39, approval of resolution plan. A PRA in the finalist, the PRA who is included in the finalist may submit the resolution plan or plans prepared in accordance with the code and these regulations to the RP electronically within the time given in the RFRP under Regulation 36B along with. So this is the stage when PRA is submitting the resolution plan. So he should take care of these provisions for the approval, because if it will be supported by these documents, then only it will be approved by the adjudicating authority. So first of all, his name should be included in the finalist, then he is eligible to submit the resolution plan. And he will submit to the RP along with the affidavit that he is eligible under Section 29A. He will submit an undertaking that every information and records which is provided in connection with or in the resolution plan is true and correct and discover Discovery of any false information report at any time will render him ineligible to submit the resolution plan or to participate in the CIRP. Forfeit any refundable deposit or attract any penal action under this code. Now this is related to modification of the resolution plan. The resolution professional, if envisaged in the RFRP, allow the modification of the resolution plan, but not more than once. So this is very important. How much like this is for only once, and it should have the provisions in the RFRP. So the resolution professional, if envisaged in the RFRP, may allow the modification in the resolution plan, but not more than once, or use a challenge mechanism to enable the resolution to improve their plans.
Ma'am, I am having a question here.
Yes.
Can I
Please.
ask?
Yes,
Ma'am,
yes,
this modification is in RFRP once, or Form G can be published once? Revised Form G. Form G can be published twice or thrice, but modification in RFRP can be once. What this circular means.
Modifications in the RFRP can be once. It is mentioned. Yes, yes. It modification and modification in the RFRP can be once, and the resolution plan, a PRA can modify the resolution plan only once.
But publication of Form G can be twice or thrice.
Yes, 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 yes.
Yeah. Oh, thank you.
Then the regulation 39(1)B, the committee shall not consider any plan which is received after due date. Obviously, because there is a timeline mentioned in the Form G, last date, and if it is received after the last date, then the committee will not consider. Received when the resolution plan received from a person who does not appear in the final list. So if his name is not reflected in the final list, then he is not eligible and does not comply the provisions of the 30 subsection 2. Approval of resolution plan. The RP shall submit to the committee all the resolution plan which comply with the requirements of the code. So RP, when the RP will make the first RP will receive the plan, he will make the due diligence of the plan, he will check the eligibility criteria, then he will form the provisional list, then he will give the time for the objections, then he will prepare the final list, then he will share the final list with the COC, and he will conduct the weighting of the resolution plan, due diligence of the resolution plan, if it is the IBC compliant plan, and if it is meeting all requirements of section 25(2)H and all other criteria as mentioned and approved by the COC, then he will submit the plan to the COC for its approval, and with the following details. Like preferential transactions, which is any application is undergoing or undervalued, or any extortionate or any fraudulent transactions, and the orders, if any passed by the adjudicating authority in the respect of such transactions. Thereafter, regulation 39(3), the committee shall evaluate the resolution plan as per the evaluation matrix. So he will, COC will compare the plan as per the criteria set down in the evaluation matrix, record its deliberations on the feasibility and viability. So COC will discuss in detail the feasibility and viability, whether the plan amount is meeting, addressing the cause of default. So COC will consider these criteria, which is mentioned as per evaluation matrix. Evaluation matrix may contain the experience of the PRA, may contain the net worth of the PRA, may contain the term of the plan, who is paying early. So it can be any conditions which can be mentioned in the evaluation matrix, and compare the plans. If more than one resolution plan is received, then it will be analyzed as per the evaluation matrix and RFRP document, which is already approved by COC. And then take the time to cast the vote on resolution plans. Where only one resolution plan is to put to vote, then it should receive the at least 66% majority of the COC. Regulation 39, approval of resolution plan, where the 2 or more resolution plan are to put towards simultaneously the resolution plan which receives the highest vote, which should be considered as approved. So there are the 2 plans. If one is getting 70% and another is getting 75%, then 75%, the plan which is getting 75%, it will be approved, whether it is more than requisite majority. Provided that two or more resolution plan receive the equal votes, then it will be decided as per the tiebreaker formula. Regulation 39, the resolution professional shall endeavor to submit the resolution plan approved by the COC to the adjudicating authority at least 15 days before. So there is a timeline that 15 days before the 180 days means when the CIF is about to complete, the maximum period is 180 days, then at least 15 days before. If it is extension is granted, then if extension is granted, say for 30 days or 60 days, then before expiring 30 days, 15 days before, it will be submitted to the adjudicating authority along with compliance format and along with evidence of receipt of performance security, because when the plan is approved by the COC, then the PRA has to deposit the performance security to the RP. The resolution professional shall forthwith send a copy of order of it when it is submitted to adjudicating authority will hear the matter and will pass the order either for approval or for rejection of resolution plan. So whether it is approved or rejected, so it is a duty of RP to forward the copy of order of the adjudicating authority, whether it is approving or rejecting, to all the participants and the resolution applicant, informing whether the plan is approved or rejected. Sub-regulation 5A says, the RP says within the 15 days of the order of the adjudicating authority approving a resolution plan, intimate each claimant, the principal or formally as the case may be, for the payment of debt. So in case resolution plan if approve, agar approve ho jata hai, then RP will intimate to claimants to make the payment of the debt, which is already mentioned in the resolution plan approved by COC and adjudicated. A provision in the resolution plan which would otherwise require the consent of the members or partners of the corporate debtor, as the case may be, under the terms of the constitutional documents of the corporate debtor, shareholders agreement, joint venture agreement, or other document of a similar nature, shall take effect, notwithstanding that consent has not been obtained. So anything to discuss till this topic, regulation 39, thereafter we will go further. So regulation 39 is dealing with approval of resolution plan. So next sub-regulation 7 says that no proceeding shall be initiated against the IRP or the RP, as the case may be, for any actions of the corporate debtor prior to the insolvency commencement date. A person in charge of the management or control of the business and operations of the corporate debtor after a resolution plan is approved by the adjudicating authority may make the application. So when the plan is approved, and a person in charge of the management and control of the business, he is doing the operations, and if he is he may take the assistance, may make the application to the adjudicating authority for order seeking the assistance of the local district administration in implementing. If he is facing some difficulties in the implementation, then he can take the assistance of the local district administration in implementing the terms of the resolution plan. A creditor who is aggrieved by the non-implementation, then he may also approach to adjudicating authority if he is aggrieved. Anything to discuss? So these are the next, these are the difficulties while RP and the PRA face while approving the resolution plan. So when the resolution plan is approved by the COC and adjudicating authority while it is under process, then PRA generally mentioned that he will propose this amount. However, he is unable to produce the necessary documents, which is substantiating the source of the liquid funds and capabilities of the resolution applicant to bring those funds timely. So in the absence of these records and documents, he may face the difficulties of approving the resolution plan before the adjudicating authority, as RP has to substantiate the source of the liquid funds from the where PRA will invest, and there can be the difficulty like which is related to the reliefs and concessions. So when any PRA offer some reliefs and concessions under the like Companies Act, Income Tax Act, and other any act which is applicable on the corporate debtor, and he incorporates such reliefs and concessions in the resolution plan. But however, adjudicating authority does not specifically mention in the order that this relief is granted or this concession is allowed to the PRA. So these are the difficulties in approval of the resolution plan, which is generally faced by the RP. Frivolous litigations objecting the resolution plan by the suspended management and unsuccessful PRAs. So when there is any PRA and who understand that we have submitted our offer, but when it is not considered by the COC, then they may file the frivolous litigations to complicate the process, and if when the plan is not feasible and viable in the eyes of the COC, then they will object as per their view. So it may RP may face the difficulties while approving the resolution plan. Other legal discrepancies may be arise like if there is any incomplete format, absence of mandatory contents of the resolution plan, when the plan is not IBC compliant plan, or any other legal or technical discrepancies may be arise which create the difficulties in approving resolution plan. Basis and premises of the resolution plan, these are the we already discussed, like when any professional start to formulate a resolution plan, then he should keep in the mind the following basis for formulating the resolution plan, like he will consider the invitation of the Form G when the Form G is published, what was the date of invitation and what was the last date of the invitation of the expression of interest, where he can get the detailed DOI. So first, before formulation of a resolution plan, he will take all this, he will consider all these factors. Number two, expression of interest process document. So he will go through the process document, which is having all eligibility criteria for the PRA. So he will mention in the resolution plan that he has submitted this EMD and he has submitted these documents and justify the eligibility criteria in the resolution plan. Then he will go through the information memorandum. Information memorandum is a detailed document which contains the financial statements and which is having the particular contents as per regulation 36A. So the professional who is drafting the resolution plan will incorporate the necessary informations which is mentioned in the information memorandum. It may be related to business of corporate debtor. It is information memorandum contains the details about the financial statements of the corporate debtor, material litigations of the corporate debtor, background of corporate debtor, what was the cause of default of corporate debtor, and these are the basic details which is generally mentioned in the information memorandum. So while drafting the resolution plan, the professional will go through all the details of the corporate debtor and will mention the plan and will describe that the cause of default is that, and how he will address the cause of default. Like he can mention the different measures for addressing the cause of default, like for if he is like he has given the proposal for acquiring the corporate debtor, then he can mention that he will incorporate new plant and machinery, he will purchase the new plant and machinery, he will purchase or he will do the merger or amalgamation with these companies. So he has to consider first the existing information of the corporate debtor, and then he will draft the plan accordingly. RFRP. So this is very important and detailed and exhaustive documents which has to be go through by the professional who is drafting the resolution plan. So request for RFRP, this contains the all the eligibilities and all the necessary requirements mentioned for the PRA, like about last date of the resolution plan, EMD details and earnest money deposit, which is deposited at the time of the submitting resolution plan, and which is performance guarantee, which is deposited, which will be deposited after the approval of resolution plan by the COC. So this document is very exhaustive document. So any professional who is drafting the resolution plan will consider this RFRP document, which is and all the conditions, terms and conditions mentioned in the RFRP, and evaluation metrics as well is very important document which COC consider before approval of the resolution plan. So evaluation and metrics may contains the criteria for deciding the approval criteria. So it may contain the upfront payment, what in how much days the upfront payment will get the priority, like it may be 30 days or 60 days, which may be decided. The background of the PRA, it may contains the background of the PRA, means if he is related to similar industrial expertise, then he will get the priority. If he is making the early payment, then he will get the priority. Experience of the corporate debtor, net worth of the corporate debtor. So this is the these are the points which is mentioned in the evaluation metrics, and it is decided by the COC before inviting the resolution plan. Valuation of the corporate debtor. So when any professional drafting this resolution plan for any corporate debtor, then he will first evaluate what are the assets available in the information memorandum. So what are the assets related to corporate debtor? So he will analyze the assets, like is it encumbered free? Is it free from attachment? Is it free from seizure? Is it disputed? Is it undisputed? So he will analyze the details of the assets and get the value, approximately value. He will realize, he will keep in mind and will mention the resolution plan accordingly. And corporate debtor ROC data. So this is also once again important point. So we professional has to mention these details. So before drafting the resolution plan, we should keep in mind that what is the status on MCA master data of corporate debtor. Like it may be active non-compliant, it may be non-active compliant status, whether a company is eligible for further filing, whether company is defaulted in filing, whether the compliance is up to date as of now. So before drafting this, because if there is no compliance is done from the last 10 years, 8 years, then again the company, when the PRA will acquire the company, then it will be so much, PRA will take so much obligations for the, if he is paying already for the corporate debtor resolution plan amount, certain plan amount, then if he is not going through this ROC database and this status on the MCA website, and if there is an after approval of the resolution plan, he will come to know that the company has not filed this returns from the last 10 years, and from the last 10 years, it will get the penalty, and it will not be easy to even if the plan is approved, even you have claimed the reliefs and concessions in the resolution plan, but it is not easy to get rid from this non-compliances, because you will get, PRA will get the problem in getting his name updated on the MCA data as a due director. He will get a problem in filing of the further forms. He may wait for the 1 year or 2 year, and he may licensing with the MCA officers from the 1 year or 2 year. So this is very important, going through the MCA master data and going through the provisions of the Companies Act, and whether so there is many issues which is arising in the relation to the Companies Act 2013, and PRA, after acquiring the company, they come to know that the company is non-compliant. Now he is not able to get his name on board. So what is the purpose of acquiring the company? So this is the basis and premises of the resolution plan. So we should check and insert in the resolution plan, and we should as well request in the prayers to get the company compliant and related to the Companies Act. We should pray separately about this database. legal, legal due diligence of the corporate, including avoidance transaction. So while this is regarding legal due diligence means when the PRA is going to acquire the corporate debtor, so he should inspect on the necessary public portals that if any avoidance transaction is undergoing, so it will obviously it is mentioned in the information memorandum and it will be discussed with COC also, will be discussed with RP also, but at his hands, PRA should make the due diligence of the corporate debtor, whether there is any like heavy avoidance transaction is made by the corporate debtor in the past, or what is the status as of now, and what will be the treatment in future related to the avoidance transactions. And then profile of profile of resolution applicant and connected parties. So it is also again important, very important. Resolution applicant should mention his background, which mention what is he is doing as of now and what is the future strategies to revive the corporate debtor. Because if you are giving the resolution plan for a company, then you should mention that what will be your revival strategy, what will be your revival, how you will revive the corporate debtor. So you have to mention the what is your existing business as of now, how you will revive, how you will invest your working capital and all, and who will be your group entities or connected parties who will help you in revival of corporate debtor and all. And judicial pronouncements. So while drafting the resolution plan, so if your case is related to any precedents, then you should refer the judicial pronouncements in your resolution plan. So it should mention all the important points which will safeguard the PRA after acquiring the company, because after the approval of the resolution plan, if these points are not covered in the resolution plan, then he will get the difficulty in implementation of the resolution plan. So what are the major content of the resolution plan document? So first of all, preliminary interpretations and definitions and observation, abbreviations and disclaimers. This is the basic part, A, B, C, D, E. So this is the definitions which is the mentioned in the IBC code. So these definitions may be inserted in the resolution plan. Abbreviations, you may mention the few abbreviations which you are using frequently in the document, and disclaimers regarding confidentiality and all. And then this is very important points which should be kept in mind while drafting this document, as this document is very much having the paramount for PRA as well as RP, and more important for PRA. So first of all, the background of the resolution applicant. As I said that PRA has to mention his background, from which industry he is related, and what is the current net worth, what is the in which industry he is engaged right now, how much experience he is having right now, and what expertise he is having. So all the backgrounds related to his business and his personal profile should be mentioned in the resolution plan. And next, about the corporate debtor. So when the PRA submit the invitation for the expression of interest, then a brief eligible.
Hello, madam. Excuse me.
Yes.
Madam, here as a resolution applicant, a SPV will be incorporated. Generally, new company will be incorporated, and that new company will not have much net worth, except that paid up capital or small thing.
Yes.
And promoters will give their personal assets and a certified CA certified net worth statement. How to deal with this situation? Because net worth of the, generally we talk about net worth, we specify in the EOI, net worth of the resolution applicant will be, for example, 10 crores. The resolution applicant company is worth of around, say, less than around 10 lakhs, initial paid up capital, 10 lakhs only.
Yes.
Yes, madam.
So you should give the plan in the name of individual now. Why you are giving the plan in the name of company?
But actually what happened now later, ultimately the company should go to a private limited company.
Yes.
That is why
So
they.
you may mention that you you may mention that if you are the proprietor, you are the director of the company, then you can mention in the net worth certificate that it is the director's net worth. So
Correct.
the director's net worth may be considered.
Correct.
Directors, because when normally in the big cases or when the admitted amount is more in crores, like 500 crores or 600
500 crores, 1,000 crores. Correct.
Yes. So when any companies give the resolution plan, then they also indicate the group company's net worth because they are sister concerns.
Correct.
So they are also included, and COC also consider that net worth. If they are having the sister concerns and having the good net worth along with, because the directors are the common. If the directors are the common, then they may consider their net worth.
Okay.
And apart from this net worth, if you have sanctioned any credit facilities from the bank, then you may show the sanction letter that you are having this unutilized sanction facilities, and you may use this facility for this plan and for the revival of the corporate return. Apart from the net worth, I'm suggesting that this kind of arrangement can be done.
Okay, madam. Thank you.
Yes. So we were on company background of the resolution applicant. So whenever any professional is drafting, though, he must emphasize that what is the more strength of the resolution applicant in he is having the good and much expertise, so he will mention in the resolution plan. So if he is very much expertise in the particular field or particular area or particular industry, then he should mention about this. He has achieved this, achieved this achievement and great achievements or good market reputation in this particular industry field, then he should mention about the resolution plan. And about the corporate debtor, so I was telling that when you receive the information memorandum, then it should have the details, means enough details of the corporate debtor, so that can be mentioned in the resolution plan. Next, company profile. So company profile means as a PRA, what is your highlights of the company? It means what is your paid up capital and what is your director's name, address, their qualifications, their experience, their what is the background. So this is the company profile about the directors and the company, and whether your company is compliant or not, and all about, because it reflects your reputation and status in the market. So you should highlight your profile. Next, shareholding pattern. So when while drafting this plan, shareholding pattern means how much shareholders in the company and how much shares is held by them. So it reflects that if there are only 2 directors, if there are 7 directors, then it will reflect the manpower. It will reflect the capabilities of the company. Like if you are having the good net worth and if you are having the good team, then if you mention and they are holding the shares in the company, then you should show your shareholding patterns that our share capital is divided in this pattern. And debt profile of the corporate debtor. So debt profile means what are the claims showing on IBPI website. So debt profile of the corporate debtor, the MCA master data, index of charge. So we can take from this database from MCA or IBPI. Then financial creditors, so we can take this database from the IBPI as well, updated database, we can obtain this. So who are the financial creditors and how much debt is received, how much debt is admitted, and on the basis of which we can propose the offer. Workers and employees liability. So in the information memorandum itself, there will be mentioned that how much employees are working, company is having, corporate debtor is having employee or not, what are their current liabilities like gratuity, EPF and provident funds and all. So on the basis of this, you may propose, after considering these liabilities of the financial creditors, workers, employees, anything, So you may propose the plan amount accordingly. So you have to analyze these database and you should obtain this database before determining the resolution plan value. Next, very important, amount due to central government and state government. So when you will go through the IBBI website, means I'm not suggesting the PRA to depend only the document which is provided by the RP. So as a professional, we should suggest that we should collect the database from anywhere, any mode which is available from where we can get the database. We are talking about GST, TDS, or any liability upon the corporate debtor which is pending since 1 year, 2 year, 10 year, like it may be related to ROC also. This is very heavy penalty, which is arise from the non-compliance of the annual returns and financial statement. Per day 100 rupees penalty means if company has defaulted from last 5 years, then per day 100 rupees. So it is very heavy penalty. So we should calculate all these things. How much amount is due as of now to central government and state government. Operational creditors and other liabilities. So other than state government and central government, there may be any liability, other liability. So we should consider this liability debt profile. So this is related to the debt profile of the corporate debtor. We should keep in mind before proposing plan value. Because we have to demonstrate this value is offering on the basis of this database. Because corporate debtor is having the good assets and having no liabilities, then you have to justify to the COC that we are offering this amount on the basis of these assets, on the basis of this claim, and so that you will able to address the cause of default, which is mandatory as per the regulations. Next, point number 4, analyzing the viability and feasibility of the resolution plan, including addressing cause of default. So we have discussed this while determining approval or rejection, COC consider the feasibility and viability of the resolution plan. So what are the points which is included in this feasibility and viability? It includes mainly source of funds. So source of funds means when the PRA is giving the resolution plan, drafting the resolution plan, then he should mention that from where he will get the funds to pay the claimants, to pay the creditors of the corporate debtor. So he has to mention the particular liquid source of funds up to the value he is offering in the resolution plan. So viability and feasibility may mainly COC consider the source of funds, liquid funds, and what is your net worth, what is your experience, means PRA's experience, PRA's background, PRA's net worth, PRA's source of fund, PRA's expertise, PRA's experience, PRA's associate concerns, market reputation, and all other factors which is mentioned in evaluation matrix. So it will include all feasibility and viability. So these are the vast scoping area for the COC to decide the viability and feasibility of the resolution plan, including it includes addressing the cause of default. Measures to successfully implement the proposed resolution plan. So in the resolution plan, we mentioned about the constitution of monitoring committee, as also mentioned in the IBC regulations. So PRA, that is the stage when RP submits the resolution plan and when it is approved. So that is called effective date. And from the effective date, he will make the payment from, like, term of the plan is the 1 year. So during the 1 year, this is the period of implementation period. So during the implementation period, who will supervise and manage the affairs of corporate debtor? So that's why there is a provision of monitoring committee, which consists resolution professional, or in place of RP, anyone other IP can be there. One representative of PRA and one representative of the COC will be there in the monitoring committee, who will supervise and manage the affairs of the corporate debtor during this implementation period. So it should be mentioned in the resolution plan clearly, so that no observations will be there after it will be submitted to the COC, because when the PR is submit the plan to the COC, it will be weighted, it will be examined by the weighting professional. Next, key propositions in the resolution plan. Key propositions means the PRA want to propose any anything which is like that he will install the new plant and machinery. He will have a technical team of experts or anything which he may propose. Key propositions in the resolution plan. It depends upon the it differ from the corporate debtor to corporate debtor and PRA to PRA. And then management of the company. This is a very important point, that who will be the new board of directors? How much capital he will infuse? So management of the company who will be the new board of directors, and how much they will invest, and how much share capital will be there after the approval of resolution plan. So it should be mentioned specifically in a specific clause. Review of the interest of all the stakeholders. So while drafting this plan, PRA should review all the interest of all the stakeholders, operational creditors, financial creditors, and other central government dues, state government dues, and unsecured, secured, any class of creditor, home buyers, FD holders, or anything. So he should consider the interest of all the stakeholders and should propose the appropriate amount for them. Story of the failure to implement the resolution plan. History of the failure to implement the resolution plans. Okay. Mandatory contents he should keep in mind, which is mentioned in the regulation 37, 38, 39. So he should keep in mind those regulations. So in the absence of mandatory contents, the resolution plan will not get approved by the COC. Conduct of business after approval. Conduct of the business after approval of the resolution plan by the COC. So this provision should also be there in the resolution plan. I told that whenever the COC approve the resolution plan, adjudicating authority approve the resolution plan, then there is a implementation phase. So who will operate the business? So it should be mentioned in the resolution plan. So PRA should mention specifically. So who will take care of the business after the approval of the resolution plan and during the implementation phase. Steps to be taken once the approval is given by the authority. Performance security. So PRA will deposit the performance security after the approval of resolution plan by the COC. Relief and concessions sought from adjudicating authority. So this is also important point. Relief, what the relief PRA is claiming. So if any relief, relief may be under Companies Act, relief may be under Income Tax Act, any other act. So it should be clearly mentioned in the resolution plan what type of relief he is claiming, and he should specifically pray to mention in the order so that it will be implemented easily. Next, separate reliefs and concessions sought from the committee of the creditors, adjudicating authorities. So whatever relief the PRA is claiming, it should be specifically mentioned in the resolution plan. But we should be consonant with the provisions of the IBC code. So anything to discuss upon this? Any member want to have discussion on this topic? Please welcome. Next, resolution plan to address. So what kind of offer he can give? Scheme of merger acquisition under the Companies Act. So we have already read this, what type of measures he can provide under the resolution plan. So this is Form H, compliance certificate. So while submitting the resolution plan to the adjudicating authority for the approval, this compliance certificate has to be submitted along with the application to be filed to the adjudicating authority for the approval of resolution plan. So this is the Form H which contains the compliance of the resolution plan and section 25(2)H, whether the resolution applicant meets the criteria approved by the So this is a form which we, as a RP, as a resolution professional, each clause of the resolution plan will be examined, and on the basis of examination, this form which will be filled. So RP has to examine the sections, provisions, mandatory contents of the resolution plan, and accordingly, he will fill this form H, and it will be submitted to the adjudicating authority. So I have mentioned these points in detail. We will discuss these points in detail. So these are the points which is weighted before putting the plan for approval of COC members. So section 25(2)H, the RP shall invite the PRA who fulfills such criteria as laid down by him with the approval of COC. So what the RP will do into this, what the RP will examine into this. So this is the point regarding Mr. Reddy asked me ki eligibility, regarding the eligibility criteria. So when the RP create a process memorandum and detailed invitation of the expression of interest, then he mentioned the eligibility criteria for the PRA, that the person who is fulfilling these criteria of the net worth and all, he can submit the resolution plan. So that RP will examine that the plan is meeting this criteria or not. So he will check this point in the resolution plan, and he will mention in the format clause number and page number of the resolution plan and whether it complied or not. So obviously it will be complied, then he will fill this form. So weighting of resolution plan, section 29A. Section 29A is all about your previous session was about 29A. So whether the resolution applicant is eligible to submit the resolution plan as per the final list of the resolution plan or order, if any, of the adjudicating authority. So this is the primary requirement for deciding the eligibility of PRA. So as a resolution professional, he will examine he will do the 29A eligibility check of the resolution plan of the PRA. If he is eligible under section 29A and complying all the provisions and eligibilities mentioned, then he is eligible to submit the resolution plan, and this reference of clause number and page number will be mentioned in this form H. Section 30, subsection 1, whether the resolution applicant has submitted an affidavit stating that he is eligible. So as a RP, while complying this, while filing this form H, he will check whether this affidavit, this affidavit, section 30, subsection 1 is submitted by the PRA or not. And if it is submitted, then we will mention the particular clause number, page number in the form H. And whether it provides for the payment of the IRP cost. So we will refer this clause number and page number. Whether it provides the payment for the operational creditor, we will refer the particular page number, clause number, and provides for the management of the affairs of the corporate debtor after the approval of the resolution plan. We will obviously it will mention if we are filing the form H, then PRA mentioned that must mention that who will manage the affairs of the corporate debtor during that period, and provides for the implementation and supervision of the plan. Also, we will refer the page number, clause number. Section 30, subsection 2, section 30, subsection 5, the resolution applicant may attend the meeting of the COC. So PRA will mention this point in the form H. whether the resolution plan has a provision for its effective implementation according to COC. So as per COC, if he will mention, obviously he must mention this provision as per section 31. So we will mention in the Form H. Regulatory fee, if it is applicable, then he has mentioned, and we will refer this clause number and page number. Regulation 35A related to whether the resolution professional made a determination if the corporate debtor has been subjected to any transaction of the nature covered under section 43, 45 or 50 or 66 before the 150th day of the insolvency commencement date. So we will mention particular clause number, page number, where the PRA has mentioned this about the regulation 35A. So we have to mention in the Form H. Regulation 38(1) amount, it is regarding amount. So we have to mention particular clause number where the provision is made for the OC, where the provision is made to the FC, and where the provision is made for the FC who did not vote in favor of the resolution plan. So we have to mention the particular clause number, page number in the form number H. Next, regulation 38(1)A. 38(1)A dealing with the resolution plan shall include a statement as to how it has been dealt with the interest of all the stakeholders. So PRA must mention this clause in the resolution plan. Regulation 38(1)A, because he has to comply all the mandatory contents of the resolution plan. In the absence of the mandatory contents of the resolution plan, it will not get approved by the COC as well. So in resolution plan, so where it is he has mentioned, we will refer this clause number and page number. Regulation 38(1)B. A resolution plan shall include a statement giving the details if the resolution applicant or any of its related party has failed to implement or contributed to the failure of the implementation of any other plan. So in the past, if he or his related party failed to implement any plan, then PRA must mention in the resolution plan. And as a RP, we will refer this page number and clause number for filing of the Form H. Next, another point we should keep in mind, regulation 38(2)A, the term of the plan, where he mentions specifically, so we will refer that clause number and page number where he is mentioned. Management and control of the business of the corporate entity during its term, during the implementation phase. So we will mention the particular clause number, page number in the Form H. Adequate means for supervising its implementation. So PRA must indicated that who will supervise, like monitoring committee members will supervise or who will supervise. So the name of the person and etc. will be mentioned specifically in the plan. So we will give the reference of this clause number and page number. Provides for the manner in which the proceedings in the respect of the avoidance transactions, if any, under the chapter 3rd or fraudulent trading. So it will be obviously mentioned in the resolution plan, and we will give the particular page number and clause number reference of. Regulation 38(3)A, it addressed the cause of default. So in the resolution plan, PRA mentioned that how he will address the cause of default. So we will refer this and mention in the Form H. PRA also mentioned the feasibility and viability, how is proving its feasibility and viability he is offering. So we will mention the particular clause number and page number. Regulation 38(3)C, it has a provision for its effective implementation. So he must demonstrate the provisions for the effective implementation, how he will implement the plan, how he will revive, and how he will do the provisions. So we will mention the particular clause number and page number. It's regulation 38(3)D, provisions for the approvals required and timelines. So when the resolution plan is discussed, then this point is also discussed. Then whose authority you will require the approval after the approval of the plan, and how much time period you will get the approval of the plan. So timeline for the same is also mentioned in the resolution plan. So we will mention in the Form H specifically. If column is mentioned in the Form H. The resolution applicant has the capability to implement. So capability will also be demonstrated in the resolution plan, and we will mention that clause number in the Form H. PRA applicant in the final list may submit the resolution plan. Obviously, we will mention in this Form H. Members want to discuss anything, please discuss. Because the session is going to be end. Nobody is here to discuss anything. Regulation 39(1)A affidavit. So if he has submitted the affidavit, we will mention the particular page number and clause number along with resolution plan. Regulation 39(1)C, undertaking by the PRA that every information and records provided in connection with or in connection plans, true is incorrect, and discovery of the false information and records at any time will render the applicant ineligible to continue in the CIRP and forfeit. So this clause, we will mention the clause number and page number. Resolution plan has submitted the details of any transactions covered under section 43, 45, 50, and 66. So while drafting and while submitting the resolution plan, he mentioned these points as per which is required as per regulation 39(2). So we will give the clause number and page number for the ease of adjudicating authority at the time of adjudication of the matter. Manner of distribution of payment, this is very important. So we have to mention this particularly ki COC decided the criteria and manner of distribution of the payment, like it will be in the proportion of voting share or it will be in the proportion of security interest. Whatever PRA has mentioned in the plan, we will refer the page number and clause number. Next, these formats related to this is the, so this is the format I have discussed with you. So these are the details which we have to mention particular clause number of the, and with compliance, whether it is compliant or not, we will mention this. Apart from this, we will check this evaluation matrix criteria also. So as a RP, while deciding feasibility and viability, COC consider these criteria also, which is not required to mention in the format, which is required to deliberate. Like evaluation metrics may have the provision for upfront cash recovery, may have the provision for discounting rates for the resolution plan period, may have the provision for the financial strength of the applicant. It may have the provisions relating to the infusion of the fresh funds. It may be related to the ability to turn around the distressed assets companies, managerial competence, technical capabilities, etc. So it can be related to EMD. So whether PRA complied those things or not, so it should be deliberated and discussed before submitting this plan and while considering the feasibility and viability of the resolution plan. So this is about format, and we have discussed submission of resolution plan, approval of resolution plan, points should be kept in mind while drafting the resolution plan, and what are the points should be considered at the time of the waiting of the resolution plan. Now our last topic is implementation of resolution plan. So before discussing this last topic, I would like to have the discussion with members, if anything they want to discuss.
Hello, madam.
Yes.
Actually, could you prepare some plans which NCLT declined, NCLAT declined, or Supreme Court declined or approved? Declined plans, you should have brought some case studies.
Okay, I don't have right now.
Yes.
Yeah.
See, I tell you, in one case, what happened? Resolution plan is approved by NCLT. NCLAT
Yes.
also approved.
Yes.
Supreme Court reversed the resolution plan.
On what basis?
See, RP, Noida, this is in Delhi NCLT, Noida Development Authority has given its land for development. So, the CD has to pay them premium. or what you call rent or whatever name you call.
To Noida Development Authority.
CD has to pay. CD failed.
Okay.
So Noida Authority filed a claim, and RP has taken its claim as a operational creditor.
Okay.
But Noida objected it, but it was going on. Later, what happened? The plan got approved. Still, the objection was there and going on in NCLT also, NPLAT also.
So they are claiming as a financial creditor.
Yes, yes, they were asking for financial because they want to be a financial creditor. But ultimately, it went to Supreme Court. NCLT approved, NCLAT approved. Supreme Court reversed the resolution plan because you classified as a claim as a operational creditor. It should be financial creditor.
Supreme Court is like treating it as a financial creditor. So there is like, so we can't we can't do anything because there is a different cases which depends. Actually, it is depends upon case to case. It depends.
Correct,
like,
correct. That is why you have to take some unique cases.
Yes.
So that learning will take place.
Yes.
Some case na you are talking about plain. What are the regulations and all? Okay, this is fine.
Yes.
If you can decline cases, yes, resolution plans, approvals, everybody will do.
Yes.
Where you can learn more from failed resolution plans.
Failed resolution plan. Yes.
And
so it can be actually failed on. There are the several criterias. Because if one small criteria is not fulfilled, then it will be rejected. And if it is not like it is, if it is not considered by the NCLT and if it is considered by NCLAT, then also it will be rejected.
No problem. So, like that, some case studies we should discuss here in that type of session.
Yes.
Okay, no problem.
Anything else? Anything
I think in Vodafone cases, sorry, Videocon cases, haircuts are questioned in Supreme Court matters, also goes to Supreme Court also. In Videocon cases, where Bank of Maharashtra, I think, filed cases, complain about haircuts. Am I audible?
Hello.
I think in famous cases of Videocon, Videocon cases, Bank of Maharashtra has raised question about haircuts.
Yes.
99% haircuts. That was landmark judgment.
Yes, but haircut is not the ground for the rejection of the resolution plan.
But NCLAT and Supreme Court also direct IBBI to make regulation on COC in that case.
So in that case, COC, if COC is approving and COC is approving the resolution plan with this haircut, then there is no ground to object or to reject the resolution plan by the NCLT as per the provisions of the IBC, because now it is depend upon case to case. What was the facts and circumstances? It is depend upon.
Take another cases also. In many cases, judgment goes against the resolution applicant. In JP cases, also, I think patent pending in, I think, Supreme Court. JP cases. Many cases already running.
It is depend upon the facts and circumstances. We have to study the facts and circumstances. Then we can say that what was the reason and what was the main rationale behind this.
Right.
Because in the many cases, one small non-compliance becomes very big issue, and like when any PRA says that he has not when any suspended management want to submit the resolution plan in a one case, like suspended management can also submit the resolution plan if he is meeting the criteria section 240A. So there can be the issue like he has not received the meeting notice of the meeting, he would not participate in the resolution plan, he has given the COC is not considered the resolution plan. So there can be the objections after the approval of the resolution plan also by the suspended management, by the PRAs whose plan is rejected by the COC. So there can be any type of these objections or applications which may be raised after the approval of the resolution plan. This may create and this may revise the decision of the adjudicating authority.
But these are process flaws, madam, procedural flaws.
Procedural flaw, yes, this is a process flaw. This is a process flaw, can be like it can be it depends. Like RP is saying that he has done all the process as well as per the IBC, but PRA is not. PRA is denying from this fact, and he is strict to his opinion. No, we have not received, and RP is showing that he has done all the things in the proper way as per the provisions. But it is depend what the what is happened, and it may go against or in favor thereafter after the approval. Can we take the break of only 5 minutes?
Yes, ma'am.
Yes, please. I hope my screen is visible.
Yes, sir.
So, yes, we were on discussion. Any other discussion members would like to have? So now we are discussing the important aspects related to the implementation of the resolution plan. So we have discussed like important rules, regulations mentioned in the IB code regarding the resolution plan. What was the eligibility criteria we have discussed. We have discussed how it is submitted, what are the mandatory contents, how it is approved from COC, what factors COC considers while approving the resolution plan, how much majority of vote it required for the approval of the resolution plan, and what are the provisions relating to the weighting and due diligence of the resolution plan, and how it is submitted by the PRA, how the approval it gets from the adjudicating authorities, and after that, after the approval of the resolution plan, it is also an important phase for the PRA to implement the resolution plan as per the terms mentioned in the resolution plan. Because when the resolution plan is approved, then it is approved on the particular terms and conditions which is mentioned and approved by the adjudicating authority. So during this phase, implementation phase, so during the implementation phase, first step is that to change the board of directors on the MCA portal. So first of all, I would like to say that there must be the existence of record of old directors on the MCA portal. So we have to remove, means the person who is doing the implementation of the plan, he will remove the old board of directors and will replace the old board of directors with the new directors. So this is also having a process under the Companies Act. So how we will remove those directors? So it will not be like on the ground of resignation. It will not be the resignation. Their office is vacated automatically under the provisions of the IBC. So what is the procedure to remove the directors? So because it is not a replacement, it is not the resignation, it is not the filling of casual vacancy on all, it is the by the virtue of the provisions of the IBC. So what is the procedure? We will file the form DIR 12, obviously for the appointment of the director on the MCA website. So we will, what attachment we have to attach so that the regulatory authority, means registrar of company, will approve the DIR 12. So I'm just explaining the procedure because this is the difficulty I have faced while implementing the resolution plan. So there are, because so much technical difficulties which maybe arise to replace the name of all the directors with the new directors. So we have to attach the documents very carefully so that no query and observation will be raised by the regulatory authority, means ROC, and they will. So normally there is a nomenclature in the MCA, in the Companies Act, that DIR 12 need not require the approval of ROC. DIR 12, when we appoint any new director, then it is straight STP format. Automatically the name of new director is reflected on the MCA master data. But when we file this form and when we select the option that it is by the virtue of the IBC, and when we enter the details of the new director and process the form DIR 12 on the MCA website, it is not approved directly. It is always will show that it is pending for approval, because ROC verify, because the power, the DIR 12, which is indicating IBC provisions, it is appointment of director as per the IBC provisions, then ROC will not approve the form automatically. This form will not be automatically approved and will not reflect that new name of new directors on the MC master data, because it will take time for the approval. And what are the documents which will be verified by the ROC? Let me explain. So in my last implementation, I have to attach various documents with the DIR 12 so that it will be get approved very easily and early. So first of all, the copy of order which is passed by the adjudicating authority approving the resolution plan, because we are appointing the director only by the virtue of approval of resolution plan. We will also attach the copy of resolution plan where it is mentioned that this director will take place in place of all directors. So resolution plan must having the name of new board of directors, because it will be easy to track by the ROC to the name of the director is mentioned here. Yes, it is proposed now, yet it is approved by the adjudicating authority, whether it is not mentioned specifically in the order. So we have to attach the order copy, we have to attach the plan copy, we have to attach a clarification letter on the letterhead of RP that by this procedure, the plan is approved and the management of the company has been changed and the adjudicating authority has approved this resolution plan, and then consequently the new board of director will takes place and the old directors will be removed. So by this DIR 12, the name of old director will not be removed. We are just adding the new director. Thereafter, we will remove old director, because as per Companies Act, two director must be there at a time in the case of private company and 3 director in case of public company. So we have to simultaneously comply those provisions also. So we have to attach these documents or any other document which is relevant to that, like we may attach the MC master data that the old directors ये थे और अभी new directors हम ये propose कर रहे हैं. So these all the details are attached very carefully with the same seal and sign, and then we will submit DIR 12. Then they will take time to examine these documents, and if they found the records in order, then they will approve the form, and then the new names of the new director will be reflected on the MC website. So this is also a
Madam,
Yeah.
change the board of directors.
yes,
Madam,
yes,
it
yes.
will happen only after the ownership is transferred. Ownership is transferred only when the shares are allotted. So
No, sir.
reduction
When the plan is approved, when payment is done, all the claims are satisfied, property for paper documents is handed over to the new PRAs, then this process will be going on to replace the change of board of directors on the FC master data, because when the PRA take over the company completely from the banks, from the creditors, and the order is approved, then this process will be done. Any doubt in this?
Actually, first that whatever upfront is there, that is infused, or share capitals, new share capital is allotted simultaneously.
Simultaneously you can do, na? Because
Yeah.
because I'm telling because this, क्योंकि आप जब भी शेयर कैपिटल चेंज करोगे वहां पे डीएससी आपको पूछेगा कि whose DSC you will affix, तो आप किसका DSC affix करोगे? आरपी का. बिकॉज अगर आप डायरेक्टर चेंज करते हो तो नए डायरेक्टर के नाम से सारे फॉर्म अप्रूव हो जाएंगे, बिकॉज फर्स्ट ऑफ ऑल आई थिंक न्यू डायरेक्टर्स ऐड होंगे तो उनके डीएससी से आप अदर फॉर्म्स भी फाइल कर सकते हो ना, रिडक्शन ऑफ शेयर कैपिटल एंड ऑल. अगर आप पुराने डायरेक्टर्स का नाम अभी रिकॉर्ड पे है, एमसीए के मास्टर डेटा पे है, देन यू नीड द डीएससी ऑफ आरपी ऑलवेज.
Madam, but lenders generally don't agree for the change in the board of directors unless the upfront is infused and share capital, new shares are allotted, simultaneously extinguishing the old shares or reducing the old shares.
सर अपफ्रंट इन्फ्यूज करने के लिए आप बोल रहे हैं तो वो तो ऑलरेडी हो चुका होगा ना. पेमेंट इज डन, देन दे विल अलाउ दिस प्रोसेस. We generally change the board of directors first.
Okay, madam, understood. So first, it is assumed that the upfront is paid, and then
Yes,
after that.
I mean, yes.
Okay, then no problem.
Obviously, otherwise they will not allow. So after that, you may change like name change, registered office change, or सबसे important change of satisfaction, charge satisfaction forms. This is so CHG4. This is.
But again, reduction of share capital, you put it as 0.5. So that is.
First of all, this INC 28 for the approval of the resolution plan and change the status of the master data. First of all, this. So first of all, because it is the timeline having the 30 days timeline. So within the 30 days of the approval of the resolution plan, you have to file the form INC 28 and change the master data from CIRP to active. This is the first and primary requirement because it has a timeline of 30 days. And then change the board of directors and CHD4. CHD4 will also require the plan order copy and resolution plan copy and clarification letter. Then it will be get approved. It is a STP form. The charge will be automatically removed, which was standing earlier in the index of charges on the MCA portal. Yes, sir. You are saying something.
No, when the
You are
lenders
telling that
continue-
reduction of share capital will be done first.
No, madam. Charge satisfaction also, the existing lenders might continue. In that case.
No. In my case, I am assuming there is
Okay.
no charge. I am assuming all payment is done.
Okay, it's a settlement. It's a
Yes.
It's actually completely giving exit to the existing lenders. Okay.
Yes.
Then reduction of share capital won't happen that time, madam. It will happen. See, when
No. This is proposed by new PRA. This is proposed by PRA that after the approval of the resolution plan and after takeover of the company, my paid up share capital will be this because authorized share capital will be the same. Like authorized share capital is the 5 lakh. Now the पुराने जो मैनेजमेंट में थे उनके पास 2 लाख का कैपिटल था तो वो कैंसिलेशन होगा कैंसिलेशन इट्स नॉट लाइक यू कैन से इट्स कैंसिलेशन
yes, madam.
Okay, cancellation, and then they will allot the shares according to their requirement.
No, it
So
is
cancellation
extinguishment of the existing shares.
You can say
and
this.
allotment of new
Yes,
shares.
allotment of new shares. Yes. But
It's
I'm
not
not. We can use this terminology also. But actually, as per Companies Act, अगर हम वो terminology use करेंगे means we are issuing the fresh share. We are not issuing the fresh share. We are just cancelling the capital and replacing the shareholders. We are just replacing existing जो था उनका उनसे हम new को ला रहे हैं. Because we don't need to follow that procedure as per the Companies Act. We will just file a form and reduce the capital, cancel the capital and allot the new share by just a form. We need not to follow the procedure which is prescribed in the Companies Act. Because it is
authorized capital will remain the same.
Authorized will be remain the same because if we cancel the authorized and increase, it will incur very much cost.
No, we will not touch the authorized share capital. Only point is that the existing shares should get extinguished totally. So
it will automatically get extinguished when you allot the new shares because it is IBC approved plan now. So we have already mentioned in our resolution plan. We already mentioned in the resolution plan that existing capital will be extinguished.
Yes.
So it is automatically extinguished because order is passed. We need not to demonstrate it through the ROC that it will be extinguished. It is already extinguished because the order is passed. Because we have mentioned all the criteria, all these terms in the resolution plan that old directors will be replaced with new directors, the old capital will be extinguished, and all the claims will be finished, and all these. So if order is passed, now it is done. Now we have to infuse only new capital. We have to allot only new share. We have to come up with new shareholders only, and we have to inform to ROC that we are keeping this capital. And we are keeping these shareholders in my company by just filing a form. We need not to follow the procedure of issuing, allotting, reduction, cancellation, which is generally applicable to a company other than IBC, which is not come through the IBC. So I'm explaining this point and pointing out this कि we will just file a form PAS3 on the MCA portal to do this compliance of PRA. Because PRA ने resolution plan में offer किया होगा कि my paid up share capital will be ₹1 lakh of consisting 10,000 equity shares of the ₹10 each. 10,000 में भी उसने bifurcate किया होगा कि 5,000 Mr. A लेगा, 5,000 Mr. B लेगा. तो मेरे new shareholder Mr. A और B होंगे और पहले X और Y थे. तो X and Y की capital automatically खत्म हो जाएगी and A और B का हमें information देना है कि we have allotted new share to the A and B and now my new shareholders are the A and B और automatically MCA पे master data पे capital update हो जाएगी. जो पहले 5 लाख थी हमने उसको 1 लाख कर दी, means 5 लाख cancel करके हमने 1 लाख अभी हमारी paid up capital कर दी है. Authorized will be remain same. Any other to discuss? Any other thing to discuss this? Because this is the this is implementing phase is very difficult also. I'm realizing this key approval of resolution plan is done now. Implementation is also difficult.
Ma'am, one more point. All the cases which are pending against the CDE, so the name of the petitioner or the name of the respondent will be changed in the name of monitoring committee or in the name of the RA?
In the name of cases which is pending before where it is pending.
Yeah, before any court like High Court or civil court or labor court.
No, so जो भी disputes है वो तो खत्म ही हो जाएंगे ना. Because we have additional waivers, claims, concessions, reliefs. What you have claimed in the resolution plan. कि मेरे जो disputes है वो तो खत्म हो जाएंगे ना. मैं थोड़ी ना लड़ूंगा after the approval of resolution plan.
Okay, all the
claims are already extinguished. Now
So, ma'am, what will happen? Oh, yeah, what will happen in the dates means we have to inform to the courts that plan has been approved and this. What will happen to those cases?
What will happen to those cases? I didn't get your point.
Is the cases which are ongoing before the approval of the plan by the NCLT. So, when the next date will come, what will happen to those cases?
So you are talking about the applications which is pending before adjudicating authority, and if it is pending even after the approval of resolution plan.
That is one point, ma'am. And another point is that what will happen to those cases writ filed or labor court cases or other cases which are pending with high courts. So who will fight for those cases or what will happen to those cases? What will be our reply as a registered professional?
Yes. So first of all, my first point is that when we propose the resolution plan, we also propose the relief. कि मेरे जितने भी केसेस जहां पे भी पेंडिंग चल रहे हैं, whether it is in high court, whether it is during the moratorium तो कुछ भी नहीं होता है, then after the resolution plan is approved, moratorium भी खत्म हो जाता है. And if we have claimed the relief, such kind of relief in the resolution plan, you are telling that हमारा ये matter यहाँ है, ये matter यहाँ है, तो it might be related to the claim, it might be related to the property of the corporate debtor, right? It might be related to some debt. It might be related to some rights or interest related to corporate debtor. Okay. So, first of all, if we are claiming all the reliefs, all these reliefs, all disputed, undisputed, whether like all type of interest liabilities, any type of claimed, unclaimed liabilities will be extinguished. So, if we are claiming these reliefs, then these matters which is pending before any court, any authority will be automatically extinguished. Because you are claiming, you are taking the company as a clean slate, not for further disputes or not for further litigations. So it is, you are getting the company clean slate as a clean slate. So I think there will be no requirement like that ki you will fight after after getting approved the resolution plan and after paying this plan value and all. So first answer is this. And
ma'am, but after paying the plan value, suppose the plan is for 1 year.
Yes.
So RA has not paid the full value of the plan. So after the approval of the plan by the adjudicating authority and before the payment of the full plan value, what will happen between this period?
Between this period, we will do listening with that authorities. That plan is approved by the adjudicating authority. Now it is in the implementation phase. So it will be like this period is that we will do listening like your property is attached by someone, like corporate debtor की property किसी ने attached ही कर रखी by chance. It may happen. But after they are getting approval of resolution plan, we have to get listening from this authority की plan is approved. Now we will get this plan approved. मतलब in person आपको वहां पे जाके लाइजनिंग करना होगा कि नाउ द प्लान इज अप्रूव्ड. जैसे हम फुल पेमेंट करेंगे तो ये प्रॉपर्टी फुल पेमेंट की भी जरूरत नहीं है, प्लान इज अप्रूव्ड. और तो कि आप एक लाइजनिंग पीरियड होता है ये आपका कि उस अथॉरिटी से आप लाइजनिंग करके और ये पीआरए विल आरपी itself order itself you do not need to take any name. Order itself demonstrating that your plan is approved in your favor because it is the court's order. So you may go and deliberate and discuss and liaising with that authority that now the property is with me and you have to release that property, you have to release this what you are claiming for that. So this is the period of total licensing period. and after the payment to the lenders, you will get the property obviously. And
So,
if
ma'am, this
still,
cost
if
will
still
be
you, if
this
still you
cost will
feel
be
the,
implementation part. This cost will be implementation cost.
no, sir, it will be borne by the PRA. It will not be borne by anyone else. And it is mentioned in the code itself, ki if any creditor is facing, if any person is facing difficulty in the implementation of the plan, then he may approach the adjudicating authority. Like,
And the second question, ma'am, any application pending with NCLT?
any application is pending, though it is already discussed while approving the resolution plan, like section 43 application avoidance transactions. So it is already like plan approval होने से पहले ही ये तो discuss हो जाता है कि who will pursue this application after approval of the plan. अगर COC को pursue करना है तो COC pursue करेगी, PRA को pursue करना है PRA pursue करेगा, who will bond the expenditure. It is totally mentioned in the resolution plan. Because जब ये plan adjudicating authority के पास जाता है तो adjudicating authority itself confirm with RP कि who is going to pursue these applications which is pending before us. तो ये तो पहले ही determine हो जाता है कि और it is also mentioned in the plan itself कि who will be liable to pursue this application and who will be liable to bond this cost. It is already decided before approval, so that further litigation cannot be raised.
Okay.
If you are not like if any PRA is not without these discussion and deliberation, the plan is not approved. And next, we have to file the form CHD4 after the satisfaction of full claims. Then the bankers will issue the no due certificate, NOC, and we have to attach this NOC with this form. And we have to attach the clarification letter, plan order copy, resolution plan copy, and then automatically MCA will change the status. Pehle wo, like it will change the status that charge is satisfied, as it will mark as status. Any other point? Or I should come to the next point. I really feel happy to discuss with professionals. So now, next topic, make the status non-compliant to compliant. So anybody is aware from this status non-compliant to compliant, or anybody is facing the problem in the implementation, during the implementation of the resolution plan? This type of error, this type of problem, anybody is facing? So generally, I want to get you aware that when any company has defaulted in filing of annual returns and financial statements for the period of 16-17 and 17-18 specifically, when any corporate debtor has defaulted in the filing of annual returns and financial statements during the financial year 16-17 and 17-18, and has not filed a form INC 22A on the MCA portal, then company will be totally restricted from filing further any form. PRA totally is not aware from this thing and acquiring the companies by putting the resolution plan, and after acquiring the company, he is not able to reduce the share capital, he is not able to file any form if the status of the company is non-compliant. So he do not check generally at the time of putting the resolution plan. After getting approved, he come to know that he is not able to file any form on MCA site. He is not able to update anything on the MCA portal. Even he has paid the plan. He has paid the plan value in crores. So this is very important point to discussion now, which is very important for me and which is I'm facing this problem. So now the PRA is not able to change the status from non-compliant to compliant and not able to file any form on the MCA portal. He is not able to reduce the share capital. He is not able to further processing of the forms on the MCA portal because the company has defaulted in the filing of the previous year returns, financial statements on the MCA portal, not filed INC 29A, which is not aware by at the time of drafting of now. If you have now, if you want to update everything on the MCA, like your name should be there, your reduction of capital should be there, you want to change the name of the company, you want to change the registered office, you are not able to do it. So now, if you want to do, you have to file the previous returns, which will cause the penalty in lakhs. Because from last 5 years, if you have not filed from 16-17, now you will file. Then he will calculate the fees. MCA will calculate the fees from 16-17, and it will be in 6 lakhs, 7 lakhs per year, 5 lakhs, 6 lakhs per year, something like that. So if you already paid for acquiring the company, you already proposed the plan, you acquired the company in crores, why you will pay in lakhs as a penalty? So this is the major difficulty which is facing by the PRA while implementing the resolution plan. And there are solutions for this, but solutions are very difficult to implement and getting delayed in implementation of the resolution plan. Because ROC will not directly change the status from non-compliant to compliant. It will have the very lengthy procedure, which will be like complicated and time-consuming process to make this status non-compliant to compliant. So, to prevent this type of difficulties, RP should take care. RP should take care while the company is in hands. So, जब company CIRP में थी, तब RP अगर ये नॉन कंप्लायंट से कंप्लायंट कर देता है या प्रीवियस ईयर की फाइलिंग लेट फी से पे कर देता है, then it can be changed only. Otherwise, PRA have to face the difficulties in changing this status from the non-compliant to compliant. He can file the application in the NCLT again कि ROC को आप order दीजिए कि non-compliant to compliant करें. ROC को request करना पड़ेगा कि non-compliant को compliant करें, because MCA.gov.in capture the data automatically. So ROC do not have any power to change this status. So e-governance cell of the MCA will change this status because it is in the powers of the CRC, Centralized Registration Center से होता है ये e-governance cell से. So it becomes very difficult to change this status and obtain the approvals of the necessary authorities. So necessary authorities means you have to change the name.
Ma'am, one question is there.
Yes.
Suppose there is non-cooperation from the directors and there are no documents, and then how RP or liquidator or RP will update the data? So automatically the city will be under non-compliant status.
So I would suggest that you should file the form which is relevant to that like financial statement and mention the clarification letter into this, because the form is filed through the GNL 2. So you can mention that we have complied from our side. No database is available and this clarification letter can be attached, and you can file the form GNL 2.
But is there any option after the approval of the plan if the status is not compliant as on date?
Sorry?
If the status is not compliant, and is there any option
available? Actually ये जो नॉन कंप्लाइंट अभी अगर स्टेटस है तो ये जो INC 28 फॉर्म फाइल होता है ना एडमिशन ऑफ CIRP, उससे पहले करना पड़ता है. एक बार स्टेटस अगर अंडर CIRP चला जाएगा तो फिर ये फॉर्म फाइल नहीं होगा INC 22A. INC 22A की फीस 10,000 रुपए गवर्नमेंट फीस है और ये वन टाइम फॉर्म है जो हर कंपनी को फाइल करना पड़ता है. रूल 25A ऑफ कंपनीज रूल्स के हिसाब से एवरी कंपनी मस्ट फाइल दिस फॉर्म. अगर किसी भी कंपनी ने कंप्लाई नहीं किया होगा तो उसका जो स्टेटस होगा वो नॉन कंप्लायंट होगा. तो अगर कोई कंपनी नॉन कंप्लायंट है और PRA खरीद रहा है तो उसे इसके लिए जो अपना वो प्लान ऑफर दे रहा है तो उसकी वो साथ में उसका भी इंक्लूड करके चलना पड़ेगा उसको कि ये पोस्ट आने वाली है उसको बाद में. 10,000 तो INC 22A का प्लस उसके अलावा भी बहुत सारी जो अप्रूवल चाहिए ROC की उसका अलग फीस मींस अप्रोक्सीमेटली 2 लाख रुपीस इसके लिए वो नॉन कंप्लायंट टू कंप्लायंट के लिए चाहिए आफ्टर. बिकॉज ये अंडर CIRP अगर मास्टर डेटा में स्टेटस है तो दिस स्टेटस कैन नॉट बी चेंज्ड. Next, this is the timeline. So everybody is aware. And this is CIRP forms. CIRP 1, from the commencement of the CIRP till the issue of the public announcement within the 7 days of the making public announcement. So it is available on IBBI portal. So when it will be due, public announcement ke 7 din ke andar. From the public announcement till the replacement of the IRP, so within the 7 days from the replacement order. From the appointment of RP till the issue of the information memorandum to the COC, so within 7 days from the date of the issue of the IM to the members of the COC. From the issue of IM till the RFRP, so within the 7 days from the issue of the RFRP, request for resolution plan to PRA. The PRA ki baat kar raha hai. PRA, when we issue the RFRP to PRA, then within the 7 days this form has to be filed. From the issue of the RFRP till the completion of the CIRP, so when any order is like approval of plan, rejection of the plan, or then within the 7 days we have to file this. Next, CIRP 6. So in what cases the CIRP 6 is filed? Filing of application in the respect of the preferential transaction, undervalue transaction, fraudulent transaction, raising interim finance, insolvency resolution process of the guarantors, extension of the period of the CIRP, exclusion of the times, premature closure of the CIRP, like settlement ho gaya matter to premature closure, and request for liquidation before completion. We can request EOC may pass the resolution for the liquidation before completion of the CIRP. Non-implementation of the plan as approved by the adjudicating authority. So in these cases, CIRP 6 will be filed. CIRP 7 is for that if any event is to be completed within that timeline, but if it is not completed, like for an example, within 30 days में IRP to RP होना चाहिए, लेकिन वो किसी reason से नहीं हो पा रहा है, then CIRP 7 should be filed within the 3 days. And जब भी वो event होगी, then that relevant form will be filed. CIRP 8. CIRP 8 is for the preferential transactions, like any transactions which is undervalued and extortionate. Then if RP comes to know, if RP determines that transactions, then 140th day is the timeline. On or before the 140th day, CIRP 8 must be filed on the IBBI. So you can discuss the questions relating to these forms also. CIRP 1, 2, 3, 4, 5, 6, 7, 8.
Ma'am, suppose CRP 5 form is filed, giving all the details of the expenditure of the CRP cost, and Form 3 in triple IPI also filed, and certain
CRP 5
expenses
for
bills are received after approval of the plan.
Okay.
Because there we have to file all the details of the cost also,
Yes.
CRP cost.
Yes.
And triple IPI also Form 3 we have to file.
Yes.
Within 7 days from the approval of the plan.
Yes.
So when both the forms are filed, and after that we receive any bills of the
Then we have to intimate through email. Am I audible? Am I audible?
Yes.
So we must intimate through email that we have done this and we have received this new information. And I have not tried to file the revised forms. I think there can be it can be filed or not, revised form. So if it
is not allowing.
So it is not, if it is not allowing, then we should also take the screenshot of this and email them. We have received this information, and but after the approval of the resolution plan, if you receive any invoice, then what will you do? You cannot do anything. Matlab, how you will pay and all. I think there is no necessity to
Because
report this.
like security guard, security.
So you already
Okay.
have provision for this, na? You must have the provision for that cost, which is estimated total CIRP cost, estimated total.
Mhm.
Because you have to provision for in like in the previous COCs ki itna total estimate aayega, because if you are handling, then you must aware ki how much cost it will
But
incur.
ma'am, in form there is no such column where we can put the estimation.
Sorry, where?
In form of CRP 5 or triple IPI form 3, there is no such column where we can put the estimation also. We have to put the
No.
actual
I'm
expenses.
telling that ki after the approval of resolution plan or before the approval of the resolution plan, you know that कितने इनवॉइस आए हैं, कितना पेमेंट कर दिया है और कितनी कॉस्ट हो चुकी है, इनकर्ड हो चुकी है एंड ऑल. तो यू मस्ट हैव द ऑल द डेटाबेस ऑफ दिस, देन यू आर फाइलिंग द फॉर्म 3 ऑन द ट्रिपल IPI. So you reported all the invoices till date. So
Yes,
you provisioned कि अप्रूवल ऑफ प्लान अगर हुआ है जुलाई में, तो 13 जुलाई में जो प्लान अप्रूव हुआ है उसके पहले तक का जितना भी कॉस्ट था ऑब्वियसली आपने उसमें डाला ही होगा फॉर्म 3 में.
Yes,
जो ट्रिपल.
yes,
तो देन आई थिंक other than this, if anything new payment or new invoice, how can it be arised? Means I don't understand.
Suppose ma'am, in the first week, suppose 1st of May, the any plan is approved and the
Yes.
invoice is received on 10th.
No, I am telling that whether invoice received or not, we have to provision the cost. We have to make the provision for the cost. I'm telling this.
Because
कि
ma'am, we
like,
can't provision the post because the amount varies. Every month the amount varies. Amount is not similar. Same amount is not like telephone expenses. Telephone expenses, we don't know how much it will come next month.
it is related to security guard cost.
Security guard, telephone expenses, water expenses.
But as
So
a
we don't
RP,
have any exact.
no. Security guard cost. So as a RP, we have decided already and we have issued the appointment letter that monthly cost will be this.
Yes, ma'am. But the amount varies because there are certain during the month we have to appoint extra guards or some guards are on leave, so the amount varies every month.
Sir, हमेशा मैं just discussing this point. Like as a RP, हमें पता है कि ये प्रॉपर्टी है कॉर्पोरेट डेटर की, हमें पता है गार्ड का चेंज भी हो सकता है ये भी, बट देयर इज अ सीलिंग लिमिट, देयर इज अ मैक्सिमम लिमिट विच वी अप्रूव फ्रॉम COC मंथली फीस ऑफ सिक्योरिटी गार्ड लाइक 15,000 20,000. तो जो एक मिस्टर ए सिक्योरिटी गार्ड ले रहा है वही मिस्टर बी लेगा, एंड देयर कैन बी द वेरिएशन ऑफ द रुपीज 2-3,000, देयर कैन नॉट बी द वेरिएशन ऑफ द रुपीज 10-15,000. So we accordingly provision, we accordingly calculate the total estimated CIRP cost. Okay, so we approve almost always 10 to 25,000 or 40 to 50,000 more than we estimate. We already, this is the general practice or this is the like prudent practice which is followed. मतलब ठीक है, आपके केस में बहुत ज्यादा डिफरेंस होता है, then it is we should report this obviously, but I would suggest कि we knows that कि what are the estimated cost which may be arised, which may be incurred, which may be need in this process, CRP process. So we should make the provisions. We are knowing that कि this will incur this cost. एंड सिक्योरिटी गार्ड का कॉस्ट भी सर अगर ठीक है, वी आर नोइंग दैट कि ठीक है 2-3 हजार उसने ज्यादा मांगा तो 2-3 हजार का ज्यादा कॉस्ट आएगा, बट वी ऑलवेज अप्रूव द कॉस्ट, मैक्सिमम सीलिंग लिमिट भी अप्रूव ना 20,000. तो इनवॉइस से मतलब नहीं है, लाइक हमें पता है कि हमें इतना खर्चा करना ही है टिल द अप्रूवल ऑफ द रेजोल्यूशन प्लान, देन वी प्रोविजन. अगर उससे कम होता है तो देन इट विल बी डिस्ट्रीब्यूटेड टू द सिक्योर्ड क्रेडिटर obviously. So I think it should be provisioned like this from the initiation of the from the date of initiation of CIRP.
Okay, ma'am.
So these are the matters which require the 66% minimum approval. Section 12, extension of the timeline beyond 180 days. 90 days period is extension is allowed, but however, beyond 330 days extension is also allowing by adjudicating authorities. So if at any time when COC resolve to put this resolution or pass this resolution, whether beyond 180 days, beyond 270 days, beyond 330 days, it always requires the approval of 66% majority. Replacement of IRP would require 66 certain actions, other actions which is mentioned in section 28. There are so many actions which can be taken by the RP. So it requires the approval of 66%. Approval of resolution plan. Obviously, it will require at least 66%. Liquidation and withdrawal application 90%. Anything to discuss upon this? Should we conclude this session or anything to discuss? Anjali ma'am.
Madam, will you be sharing the PPT?
Yes, of course, I will share.
Thanks, ma'am.
Very much, ma'am, for such a nice and wonderful presentation. And ma'am, you are requested to share PPT with.
Yes, ma'am. Of course, I will share to you. Then you will be able to share all the participants.
Yes, ma'am.
So, ma'am, should I conclude the session as there are no agendas or points to discuss?
Yeah, ma'am.
Or should I wait?
Ma'am, we can conclude.
Sorry?
We can conclude, ma'am.
Yes, ma'am. Sure. So thank you very much to all participants for joining and giving your valuable feedbacks and insights to this session.
Okay,
and,
madam. Thank you.
Please keep in touch.
Thank you, madam. Thank you very much.
Madam. Thank you,
so
madam.
much.
Thank you, madam.
Thanks for the wonderful presentation.
Madam, you will be sending CPE letters, mail. Hello?
Yes, sir, we will send on Monday.
Monday you will send CPE letters. Okay, madam. Thank you.